Thank you, Judge. So here the petitioner participated in the Jagdalpur sand verify, and he was the successful bidder. So Lordships will see page 21, annexure 3.
Where is a notice dated 1/8/22? Where is the notice dated 1/8/22?
Annexure 1.
Give me the page number.
Well, it's page 12. This is the auction notice. That is not in dispute now. Only the problem is that the authority is saying we are unable to declare you as a successful.
Where they are saying?
My lords, page 21 if your lordship will. Annexure 3. Now, this is a letter by
Just wait. This was written to the Additional District Magistrate. What he has said?
The next page is the clarification. First paragraph itself clarifies. First paragraph, last two.
Yes. So there is no difficulty then?
No difficulty. Now, the authority is saying that there is a writ application pending.
No, they have not. They have already clarified. They have not said anything.
Fine.
Direction was to proceed.
Okay.
Then they're saying that two issues they flag. One is whether an HUF at ITR can be treated as an individual ITR.
Fine.
Clarification has come that both individual and HUF can be accepted. No difficulty. So far as the GST part is concerned, the clarification came. They have to certify that there is no dues. That's all.
Fine.
Nothing more than that. Then what is our grievance?
Thereafter, they're not proceeding.
That is why you are keeping tight over the matter.
Annexure 5 at the top of left hand side top. It states the authority has received in his office.
Why you are not doing it, madam? 2 years have passed.
In June
Clarification has come on the month of December 23.
25/6/25, the mining authority has received it.
Yes, Your Lordship.
Their office.
Yes, Your Lordship.
Right.
That is
Seal-
there in
Seal
document.
shows that. Seal and signature.
No, that is his representation.
Representation.
What are you doing? Why you are not taking?
Lordship may I seek instructions, Your Lordship, as to what has actually happened here. Or Your Lordship may dispose of matters saying.
No, we are disposing of. We are just saying that go ahead with this. There cannot be, the authorities are not supposed to sit tight over the matter. Yes. The tender was floated.
was. Now, the elections were issued in favor of the petitioner under Annexure 1.
Just it. Sir, there was a representation, the hearing was done, it was concluded, but you have not taken any decision now. More than nearly 2 months have, 2 months have passed. 12/9 was the date of hearing. So we are in practically on 11th of November, 2 months.
He has a leave.
Your lordship will keep it to Thursday, your lordship. Whether they have already passed the order or not, your lordship, in the meantime.
We are disposing of directing him to pass an order within a period of 2 weeks from date, if not already passed. Sir, what do you expect? 2 months period
Because my lordship
is not that inordinate delay.
in
2 month
December,
period, we
license
can
is-
say the reasonable time, he should. What more, suffered a lot.
the license.
Your prayer is something else, we are granting that prayer. Can you increase?
My prayer is to direct him to actually to give license for additional.
No.
Excise policy.
No, it says that approve the license for the additional bar. That is what they have to.
Yes.
Sir, you want them to become more wise if I make some observations.
No, Senator.
You know what is what. So if you want, we can simply decide this.
Within 10 days. Because
What
the
10 days?
license will expire on December.
Whatever, I do not know. It's an additional license. Is not relating to the original license.
Yes, your lordship.
No, that is not there. Anyhow, anyhow,
5 months.
we are not making any addition. Lago. The petitioner Yes, give me.
What's the short issue here is the
Ratify and regularize the quarry lease agreement dated 29/11/2024. Lease agreement or a lease deed?
this deed.
There is a vast distinction between an agreement and a deed.
I admit. My learned friend has committed the mistake. I acknowledge that. I take up the responsibility. I try.
Where is annexure 6? What is is whether there is any provision relating to the renewal?
There is no provision for it. But why I am today for my notes? The minor mineral Sairat belong to Lord Jagannath. The source belong to Lord Jagannath. Now, the entire procedure of putting the option of Lord Jagannath minor mineral Sairat source previously was being conducted by the sub-collector.
Sub-collector.
But fact remains that under 2016 rules and also in the previous rules, competent authority is the same. To put a Sairat in auction, advertisement to be published by the competent authority.
Now mining officer has come.
That is why I am before. Now what has happened here is sub-collector initiated the auction process by open order without having jurisdiction. Now, pursuant to the advertisement, I participated.
But there is a special act concerning the properties and the assets of the Lord Jagannath. There is another special act which is.
That is Lord Jagannath Temples Act.
That's true.
That will not govern.
Because why?
See, because the settled position, the judgment, the Kukkumina construction judgment is there. In case of Sairat belonging to Lord Jagannath, it will be under the minor mineral concession rules. There is a judgment. There is no dispute about this. So minor mineral concession rules.
Then how this royalty and all everything will go to whom?
Lord Jagannath.
So
say they only do the auction.
Because the normally what we understand that even Article 300 capital A of the Constitution, it permits that is a constitutional right of the person to hold the property. No difficult. But any natural resources beneath the land or the property that belong to the state.
That's right. Belong to the state.
Belong to the state.
Yes.
So even an individual who is owning the property or the land does not have the natural resources.
No.
One principle.
Yes.
So if that being the position, then if the land belongs to Lord Jagannath, that is a surface land which belong to it.
Not the
he can use
minerals.
Then why the royalty goes to Lord Jagannath?
That is a professional state has been benevolent to give it to Lord Jagannath. They are doing it.
That's a grant. They collect it and then they remit it as a grant or whatever.
Yes.
But collection of the
Lordships are correct. That beneath the soil, whatever is there belongs to the state.
I think it will be clarified by the advertisement itself. The advertisement is floated by Sri Jagannath Temple Administration.
That is what I want. I have seen that.
And it is not by sub-collector. Sub-collector is the authorized authority.
Yes.
To function on behalf of the.
But it is done under minor mineral concession rules. Procedure is.
It has to be.
It has to. So
it has to be.
So, but what is the issue that has taken up here?
But again, I am saying that this rules is a subordinate legislation.
Yes.
The act is a substantive law.
Right.
If there is a conflict between a subordinate legislation and the current statute, and the special statute will definitely prevail over the general the rules.
Canada.
What is this? A specia generalis or something? What is that legal maxim? I never
Very difficult
could pronounce.
Specialibus
Generalia. Reverse is also true.
Yes.
Sometimes.
So what is the problem has cropped up here is now sub-collector has conducted the auction.
No, not derogation. No.
Specialibus.
But there is
Not
generally
general.
and generally a specibus. But it is
Specialibus.
That can be taken out. But sub-collector has conducted the auction. Now sub-collector's auction, we entered into the lease deed. Now we have taken the mining.
prior to amendment.
Prior to this mining officer No, after
That's
the
the prior to amendment or after?
After.
Prior.
No. The option is prior.
Oh, no. The already continuance of the mining lease, I am just trying. 24.
Yes. Option is prior. Not see. Option your Lordship may see 11th of February 2019.
Oh, then it was prior.
Yes, it was prior. Now if your Lordship sees 6/11/24, the agreement was executed on 29/11/24, whereas transport to mining department on 6/11/20. That is the date. 6/11/24. These entire operations to transport to the mining department. Now, we entered into agreement with sub-collector on 29/11/20. I'm sorry, lease date, 29/11/20. But be that as it may, the issue is something different. Now, the sub-collector's option up to another option was set aside by this Honorable Court in a judgment, saying that sub-collector did not have jurisdiction. So once the sub-collector's lease deed and option was set aside on the ground of jurisdiction, we are not parties there, nor we are in the prey of that case. Now, as a fallout of that, our agreement now is put at stake after 3 years. Now, the collector is saying that I will not give you blasting permission because your auction is by an authority having no jurisdiction. High Court has passed it.
But that was a case of, that must be a case after the amendment that has been done.
It was same.
Or prior to the amendment,
Prior.
2019.
Prior.
How it has been done?
Prior to the amendment, my lord, referring to clause 2F of rule, my lord, the Orissa minor mineral concession rule, which speaks about the competent authority, read with the schedule, this Honorable Court, division bench.
When that amendment came,
But the amendment came in the month of December, my lord, of 2022.
2022, if the auction was held
Prior to that.
prior to 2022, and this is really a continuous process.
Yes.
The only inconsistency, or I do not know, can be perceived is that so far as the execution of the lease deed is concerned, the execution, whether it would be done by a mining officer or it is by a tehsildar or the collector, whatever,
Yes.
is the question so far as the
Under the
execution of the lease deed is concerned. But once the process is initiated prior to amendment, and the law, I think the Amendment Act says that it will be transmitted, all the records will be transmitted
Yes.
to the mining officer. That does not invalidate the action already taken by the tehsildar. He is not sitting as a court of appeal over the decision of the tehsildar. He has to simply continue as a competent authority, because in the meantime, the definition of a competent authority has undergone a sea change.
But here the irregularity was pointed out under the pre-amended rules. Your Lordship may kindly see the honorable.
What irregularity?
That is what I am saying.
Earlier, Tahsildar was the competent authority.
Oh, sub-collector was not.
Yes,
Okay.
that is the issue. Which
That is why I am
this
for
honorable
rectification.
court, my lord.
Then what?
That is why I am before your Lordship.
So what for?
But it was conducted by an authority having no jurisdiction. That is
To have a blessing in disguise.
void document binding inter party is still set up.
Void process also.
Yes, void process also.
Then everything goes.
But that is why I say, very recently, 2015 Honorable Supreme Court has said, if a process is initiated, mining clear approval is given, environmental clearance is given, agreement and lease deed is executed. What I am saying is that can be ratified by the authority having jurisdiction. If you
No.
look at 2015 Supreme Court, that if it is kindly seen.
I think the de facto doctrine will not apply here.
But your Lordship
No.
will find it's not a
It's
it's a case.
No, even a factum vele will not
Lord,
survive.
kindly consider this one. It's kindly
Cannot.
take this 2015 Supreme Court and kindly consider.
De facto doctrine will.
28
Prior to that, your Lordship may refer to the order passed by this honorable court, my lord.
given that.
The order passed by this honorable court.
It's a concession.
But it's not my mistake. Kindly consider this. It's not my mistake.
This
We-
judgment
we-
has no presidential value.
Yes.
No precedential value, but the honorable court. referring
No,
to the
we
statutory-
can't apply this. This entire judgment is founded upon a concession having made by you.
Concession made by the Sri Jagannath Temple.
Whatever.
Association.
And on that basis, the concession, the entire thing has been decided.
My lord, but my lords have referred to the provisions, particular provision, and come to the conclusion that The sub-collector is not the competent
Kindly
authority.
see, my lord, para
And
28.
IA petitions
One
were
second.
filed to recall that order also.
One
Those
second.
applications have also
Para
been
28, your
rejected.
lordship, may kindly. 1 second, I'm citing it there. Kindly. You can't.
You are citing a judgment delivered in a service jurisprudence.
Service.
In a contractual field you wanted to apply.
I am relying upon the ratification order. That's all.
It's nothing. Service jurisprudence is
I
different.
give it to my lord, but your lordship will kindly consider on the ground of equity also they have some point in their favor because on your representation we participated. We paid money.
Sir, this cannot be. If the foundation is found to be wrong, illegal, then whatever is built, even a castle cannot stand.
Can
It
I
has to
suggest
fall.
something? Can I suggest
No,
something?
sir.
Can I request your lordship to do? Lord, it's a case to save these people. They have invested huge money here.
Whatever. You can claim a damages in this regard.
Can I suggest some respite for these people? Lord? Let the government take a call and take a decision on this. Lord, we'll approach the government.
They are denying your blasting permission.
No, that's why we are not
So
operating.
now they have not taken any decision
So
to
that is why I say
cancel the lease.
so let them take a call. Lord, take a conscious decision in the matter to save not only this, my lord. There are lot many people are there.
No.
If government takes a decision on this, at least take a call and take a conscious decision on this. This will redress
The
our.
consensus decision would be the cancellation and
That may not be, Lord. They can cure this defect, Lord. They can
Rescinding.
cure this. They can amend the law. They can take up any action. They can amend the law. They can
What
cure this
amend?
because this is an
What
action taken
amend?
in the interest of Jagannath Temple. We have paid money. We have taken mining approval.
we understand.
Right, madam. Equity is there.
The intention is, but equity in accordance with law.
No,
If the law and equity is
I-
pitted against each other,
Instead
is a
of
law which will prevail. You have cited the judgment.
I given the judgment instead of joining issue there.
So-
I'll lordship may
So
give
if the
some-
law which will take its course, if the law does not permit sub-collector as a competent authority, and it is a Tehsildar who was a competent
But
authority, whether any action taken
there my
that can be rectified.
But there my submission is, lordship will kindly consider, these are all governed under Jagannath Temple Act. Now Jagannath Temple Authority have allowed sub-collector do it. Kindly consider this. From the beginning, your lordship fell out from my lord's mouth correctly because it is under the Jagannath Temple Act, the administration authorized the sub-collector to do it.
But the difficulty is that once the natural resources beneath the surface land comes, then the OMMC rule will come,
That
and it cannot be tailored for a one purpose and for the other purpose a different no.
No,
It
your
should
lordship
be a
will-
uniform one.
kindly see the option notice.
No.
Kindly see the option. It's not completely without jurisdiction. It is as an authorized.
Administrator of the Jagannath Temple
Committee.
has authorized or whatever the committee. The committee does not have any power.
They have.
What? Beneath natural resources, minerals. Definitely not.
But beneath, they are not doing it in the manner of beneath.
No.
They are not doing it. But irrespective of, can I just put a small request, my lord? Let them approach the government. The government has the power of eradicating the defects. If they can do it, they can do it, my lord. Not with that observation, with that
We
liberty.
can't compel them
No,
or issue mandamus.
No, mandamus. We not give that.
No mandamus, we can't.
Give that liberty to the petitioners and direction to. Yes, ma'am.
Do you want to have any observation? And then, will you have any observation? Then we will pass on.
Then we will detail. We'll consider both the acts.
Foundation goes.
Everything will go, ma'am. But can I just?
Then we will extract both the provisions. What are the powers of the committees
Once you are
under the Jagannath Temple Act?
I am nowhere. But kindly, just one page. Can I show your lordship one page? 127 kindly see. They have sought for clarification on this. They have also proceeded on my grievance.
So let them
So
take.
that is why that's what
Let
I am
them
saying
take.
before my lords. Kindly see my lord, page 127. 10th of October 25, they have sought for clarification from the temple. How kindly see my lord, page 120. Therefore, it is requested that clarification be provided as to whether ratification of the lease.
No, it is only in the month of
Are
October.
you serious in continuing with this? Because then we'll have to make observation on this letter.
I will not require any observation.
Then
from
whether
with only
whether
enough
this
of-
letter, with this letter can be done, because we have to then decide
No,
that for the
no,
purpose of mining, what should be the law?
I will not compel my lord to decide this. I will only just an innocuous observation. Let the government take a call on Annex 16 and take a decision on their in their wisdom, in their own wisdom.
No, it is only
Kindly
in the,
consider.
no, it is only in the month of October. The Deputy Director Mines sought for. Pursue that.
Well, it is,
Pursue that if otherwise on merits we will dispose of this.
on merits,
brief
lordship, not instead of dismissing matter.
You wanted them to become more wise from our observations.
Even if they become wise, I may again come to before my lord.
So one thing is, was it warranted by a deputy director mines to approach the committee?
Our grievance.
What right the committee has?
No, the committee, they are writing to the committee.
Yes, how? And
This
seeking
is on
clarification for what?
On our representation. We are requesting them, please ratify this.
No. So is the committee a competent authority? First question.
No, committee will not ratify. It is
Then-
binding
then-
officer will ratify.
Then
They are-
we'll have
they
to
are
say
trying-
that this was absolutely a farcical approach. It would not yield any result,
Instead of.
because the committee is not empowered to either grant or take a decision on the mining lease.
So lordship will just permit me to move them and directing them to take a decision. That's all, my lord. Without any observation on merits, my lord. Your lordship may say that your lordship has not expressed any opinion on merits.
We are avoiding. But if you invite, then we are.
I'll never invite my lord, save and accept an innocuous observation that to take a decision on our grievance. That's all.
Again, it will augment that representation theory.
No, representation, my lord.
Consider the representation, decide it.
Looking at this development, it's a case that we have substantially progressed here. And we are operating since last 3 years.
Maybe that's good.
We are operating since last 3 years.
Should be happy with
Now
that.
it is stopped.
Should be happy with that.
We are happy definitely. But then just that observation, I'll go back to you.
What is this mine?
Blackstone,
Blackstone.
Boulder, building material.
They approached, presently they approached the Sri Jagannath Temple Administration. Temple Administration directed the Deputy Director Mines to take a decision. Now, in view of the statutory provisions, they cannot take a decision. Only they have, in return, they have responded to such letter and written it to the Temple Administration that you clarify what can be done, whether it can be ratified or not. They have no
Take
other
a
option. They have to
conscious
go by
decision,
the provisions of the statute. They
Let the
cannot.
government take a conscious decision, that's all. That will end the problem.
But they will be entitled to damages if they have suffered a loss.
Yes.
Because of this, your action. Then they are entitled to all the damages which they have suffered. You'll have to compensate them.
Regarding that, the Temple
It's a misdeed which is, or not misdeed, it's a mischief done by you.
the
How an innocent person who participated on the basis of an advertisement in the tender process, selected, invested, continued, and then later on you started saying that your initial initiation that was wrong because the sub-collector did not have the power to do so. We appreciate it. Now you realized after 4 years, 2019 process.
Yes.
You realized after 6 years, now you realize that what has been done.
he was put to auction by the Temple Administration.
Temple administration will
Both are mischievous.
Agree was put to auction by the temple administration, my lord.
Yeah, you are representing all.
What are you doing? Had there been a provision in the special act that who will be regarded as a competent authority for such purposes, I could understand. But in absence thereof, then what to do? And then and the sub collector has proceeded on that basis. And who will suffer ultimately? The Lord Jagannath who will suffer. Because if any compensation is paid, you will charge from their fund. That's can't be.
More the merrier is collector district magistrate has given into permission to blast.
Already granted blast.
Yes, yes.
So you blast.
But now they are not.
Blasting permission has been rejected.
Now they are not giving.
No, my brother says that there is one permission.
Your lordship may kindly say.
Annexure
Annexed previous year.
previous year.
Valid up to 31st of March.
Annexure 14, your lordship may kindly say.
Then your lordship may
That is why
kindly
they are.
Yes. Serial number 1.
injection to the-
Even then he had no authority.
You wanted a blasting permission,
from the
But-
collector.
but
Because
they
they
have
have-
blasted you.
How you blasted us? He will blasted us. Page 120 man.
Pollution control also you have got.
We have got pollution control board, SIA approval, mining approval, every consent to establish, consent to operate, everything. And you know how difficult is this to procure.
Temple administration better.
No. Issue no.
Been rejected in respect of as many as 20 queries. The lordship will find at page 120. One of them is the petitioner's claim. In respect of all
My
query, they have.
friend is asking, the rest 19 will come to me or what?
You can't refuse the blasting permission on that score unless you receive any cheat, cancel the deed, make a re-entry. So long that remains, and then you have given a blasting permission on the last one. Simply saying will not do it. What steps you have taken for cancellation of the mining deeds?
Regarding
You have
that,
not taken any decision till now.
regarding that, I have no instructions.
You have not taken, sir, that shows. That shows.
You may keep it to Monday, I will take instructions.
Next year, this largest commission is.
This lease deed was on 29th November 24.
What can I expect now? I come 45 or 20.
Only double 24.
You have not challenged this order of 23rd September 2025.
We are not parties there, nor we are notice there.
No, your permission for blasting has
No, not
taken.
mine.
You are not challenging.
Not
it.
mine, Lord. That is another batch of persons.
So
Not
are
me.
you not coming within this 20?
No. We are not coming within that option.
There are as many as
No, Lord. Other batch was there. We are not coming. in.
30%.
We were not there. Our option is not covered by that. Maybe by
No.
the sub-collector, but not by the same option.
Then,
Name of the petitioner finds place at serial number 6, man.
Who that?
yes.
Page 120.
Oh, yes, you are there.
My
You are
Lord,
not challenging this order.
my Lord, kindly consider. This order, 22 order for some other persons, and that order is being applied to us.
Whatever be the reason, sir, it simply says that such and such is not a competent authority.
That's all.
For auction and sale have been done. Settlement of sources have been done.
Kindly see that order.
Violating the statute.
But I have been,
Application is rejected.
but kindly see that order, that 22 order. I was not a party there, nor my auction is covered in that petition. This is something,
This
yes, in this order. I was not a party there, nor my auction is covered in that order.
Do one thing, we are watching so far as he is concerned, take an independent decision, write the same letter in a different get-up.
In that case, I'll challenge.
Before us,
Your Lordship,
before us.
my lords, the element is with your Lordship and medicine is also with your Lordship.
There are certain incurable diseases.
That can, but they will try to find out some ways in which happen. Let us see, Lord, what happens.
This particular, decision.
In the process, they may take a call.
This number.
Settlement sources have been done by the sub-collector Khoda, violating the statutory provisions. That also they have referred. And not only the order passed by this.
Therefore, Mr. Subhutu Swatapati,
Yes,
who was representing the administration.
Yes,
my
He
lord.
conceded that yes, sub-collector is not a competent authority, Tahsildar under the OMLC rules.
Yes.
And on that basis, on a concession, this order was passed.
Yes.
So far as the order passed on a concession is concerned, that cannot be applied uniformly against the third party. This is not a party to the said proceedings, as a proposition of law. But one has to take a conscious.
But in the present case also, your lordship.
Now suppose if it is, there was some confusion. Then in that event, what will happen? In Jagannath Temple Act, if the competent authority is also provided for the purpose of, let us see the Jagannath Temple Act.
Ten. One.
committee.
1510.
Your lordship will get.
I have seen 16 is
Right,
allocation.
so great.
That will not come to your aid.
That's all.
It was executed by the sub collector.
It was by the sub-collector. Not it is page 68. The Governor of Odisha represented by sub-collector. And competent authority. He writes such competent authority.
ଚିଠି ମାନେ କରିଥାଉ ଚିଠି
My learned paid for the state. I'm sorry, to take instruction. There is a letter issued by the government, no? Government nominating sub-collector as competent authority so far as Jagannath temple property that is. Yes, yes, there is a letter. Yes, yes. He is writing competent authority. Government has issued a letter. A letter was there.
ଚିଠି ପଢିଛୁ ଦେଖିଛି ଡିସିସନ ପରେ
The temple administration has already also been added as a party to the present petition. Lordship,
Notice to government council. Six.
Item 4.
Two weeks. Notice.
Item number 4.
Online,
Yes, sir.
IMFL,
Yes, sir. Not IMFL, it's country,
with the,
country speed, country speed. Country league. Right.
no legal.
Yes. sir.
You cannot come out of the legal.
That is. Lordship's assignment is there, so. What is, what happened? Your Lord, the pin number 5 is operating his country liquor shop other than the specified premises in his license and in violation of Rule 52A. So, Lord, in this regard also I have approached the collector and commissioner, but nobody is, Lord, in the month of August I have given application to that he is operating and is creating disturbance, and Lord, I am not able to lift my MGQ because it is my near. He has been awarded the license of to open the shop in 42, but he has opened in ward number 43. And the land document which is given to the authority,
What is
he has
your
not
right in
opened there
42?
also.
What is your right in 40?
No,
What is your right in 43?
no, 43, what?
You said that he
Yes.
is awarded the license for ward number 42.
Yes.
He has opened in 43.
Yes, Lord.
I am asking, what is your right in 43?
I am licensed, Lord. I am also licensed.
What, 43 or 42?
No, I'm in 55, just never in that one.
And there is no shop in 43.
No shop in 43.
Not 42.
He has opened 43. The open number 5 opened in 43, but he has awarded it.
It's not the hidden object.
Lord.
What, why?
42, 43 is where he is exercising both, Lord.
Yes.
Because that is both connected one.
You are in the competitive market.
No, I'm also not. I'm not able to lift my MGQ because he is also selling there also in my area.
Not in your area, sir. 53
But,
is
Lord,
55.
in my area also is selling.
Please, you have not raised a grievance.
No, I've said.
What?
I've said that my MGQ is not. I'm not able to lift my
he's
MGQ.
selling- He's
and
selling in that area. He has opened an outlet there.
no,
In
no,
your
no,
area.
no, no.
Then,
Unauthorized, he said.
then
Unauthorized.
unauthorizedly means what?
No.
By putting stock somewhere in your area,
Yes, Lord.
making an outlet.
No,
for
no,
access.
not there in Kochia. That is called Lord Kochia sell.
Means-
People are selling liquor unauthorizedly, taking
That is-
liquor
that-
from his.
that is up to them. You can't
No,
impose. If somebody goes to the shop and buys a good, and then if what he is doing, the shopkeeper is not supposed to know what he is doing with my stuff. He has simply sold it to him. And if he
But-
goes there and does it, then this authority will take care of that.
No, that I have brought to the
You can't
notice.
blame him.
I've taken the notice of the.
Once you sell a good
Yes,
to a particular person,
yes,
your liability and receive the payment, your liability is
Yes, yes, ma'am.
gone. Now that seller or a purchaser, what he does,
Not my grievance is only
is
that
none of your business.
if he'll open this in his area, then there will be no shortfall of MGQ in my shop.
What?
If he'll be open in his area in ward number 42, then I will be no problem. I can sell my liquor and I'll
43.
lift.
In 43.
43 is the problem, Lord.
No,
43 is making.
then you can sell it in 43.
No, I will not sell.
No?
I will sell then
He's
But-
selling in 43.
but he is encroaching, Lord.
What is your
He is
problem?
encroaching. That is the.
Show us the one evidence that he has opened an outlet.
No, there is no.
Then
But Lord, as per the law, 52 says that he is to open his shop in his locality.
Within his allotted area.
Yes.
Where he has shown, he will open the shop in that premises which he has shown.
Yes.
He has opened it.
Lord, he has made forgery. He has given documents of rent agreement, some other plot, but he has opened in another plot. That also he has done. That I got in the under RTA.
They have given a license for a, they mentioned that.
No, no, plot number has not, in my license, plot number has been mentioned. In his license, OP number 5, no, plot number has not been mentioned.
How it can be done? Probably these licenses contain that particular premises because it is a license granted on a premises.
Yes, that is not there.
Yes, Ms. Patnaik, what are you? It says,
Seek instructions, Your Lordship.
this. Can it be done in this way?
Your Lordship, let the excise department tell me if what, property he has taken on rent, what documents he shows. Yes, Your Lordship.
Yes, raised these objection, parasite, seven.
Yes, Your Lordship, para 5 and 7, and he's also stated in his,
Clearly he states. That he is
He is
actually
also-
allotted to open in ward number 42, not in any other area, but he has opened it some other area.
We do not make an inquiry, we do not do something, if such a serious allegation is made.
Lordship, also in para 4, he has said that ward number 43 of CMC belongs to Sri Ramachandra Sahu. That also has to be ascertained whether it has already been given to someone else, Your Lordship. Lordship, I keep it to next week, Your Lordship, I'll see. Whether they've conducted an inquiry or not, Your Lordship, also that has to also ascertain.
They are to know.
Yes.
Item number 5.
And analysis here 49 minor, next to 4 minor.
What?
This is a show-cause notice for imposition of penalty. This is the lessee of Blackstone, the Arwa Stone Quarry. And after receipt of this show-cause notice minor, on page 50 minor, by annexure 5, the petitioner submitted a show-cause reply since 4/8/2025 minor.
Yes.
And the mining officer is sitting silent and is not taking any decision with this now.
Yes.
With the mining officer. Here, in absence of environmental clearance, operations were carried out, mining operations were carried out, then the vehicles were seized. And the mining officer, by virtue of annexure, my lord, that is 4,
Yes, he has imposed a penalty.
he has not
No, show-cause
imposed,
notice,
it is only a,
imposed.
He's contemplating to impose penalty.
yes, this is a show-cause only, and
I
my,
don't know.
well,
He says, he's given a reply.
Mine.
my learned friend has given a reply by annexure 5. If it is pending, let the authorities
They
take it.
denies that those vehicles are not his.
Not his. But the vehicles were seized from the.
From his premises.
Yes.
You know it then, why you are picking that, you know the field. This kind of a reply, you know how to deal with it. So. I've been forced to again revive that particular concept of consideration of representation. So. Now the lesson. Let me not dispose of it. Don't see the please look at this. It is really a sorted state of affair that despite a show cause notice having issued contemplating to impose
The order dated 23rd September 2015 passed by the Tahsildar Barsainder, that the order in which the cancellation of auction process was cancelled, my lord. After that, he remitted to the mining department. By virtue of, my lord, the amendment of December
When the
2000,
amendment came,
my lord, amendment coming to your lordship 27 December 2022, your lordship. So the order is renewed, and your lordship judgment, I
the
understand.
mining officer who has to do it.
Yes.
Mining officer, here what has happened? The,
Maybe process was initiated by the Tehsildar,
yes,
but it was not finalized and they wanted to cancel it.
it was not finalized because it was on the basis of a interim DSR report, which is the subject matter before
Sir,
the
whether all these
National
decisions
Grievance
can be taken
Tribunal.
by the mining officer. Can be taken by the mining officer that these are the faults, these are the things which was not followed. You can take a decision for cancellation after the amendment.
But after the amendment, he can take it.
Can he resume or assume the power?
Well, he has only cancelled. He has only cancelled to go for
Can he
press.
say anything on that? Can he put a bracket? Can he put a comma? Can he put a full stop? After the change of the competent authority's definition?
So file has come to the past in October. You have taken a decision in September. Perhaps
Whether
at the-
he dispose of the matter saying that it cannot be done, separate this order, he is removed upon. And the entire record he has already transmitted, including this mining officer to take a decision for cancellation, whatever the decision that he takes.
That is your lordship judgment, page
Yes,
40,
yes.
14, opportunity of hearing. Yes,
Because in the month of October.
Yes, yes.
That was delivered. He has taken decision in September.
Yes.
He had no knowledge about.
Exactly.
Perhaps.
So the, I said,
Yes, ma'am. I love it.
Item number 7.
Here, 7, challenging the inaction. Challenge. My lord, the Kori lease was granted in 20.
why you wanted an extension?
My lord,
Why you wanted an extension?
because my lord, for their latches, I am unable to operate the mine till death. Your lordship may kindly, I have stated in detail about how the matter has been.
Concept. You are really augmenting the litigations to come to the court. Had you taken a correct decision, I mean, the wrong decision, I think we could avoid this. Why you are not taking a decision? Either yes or no, whatever you communicate the one. To extend or not to extend. Yes.
Here, my lord, there was a delay in production of the environmental clearances and other,
I do not know this.
He could not operate.
yes,
That was,
Your latches.
but in absence of any
So
specific
that
conditions
you
of
not-
contract.
Is it
in
not
the-
your responsibility to either say, yes, I grant, or say, I will not grant? Tell him.
Yes.
clearance is also given by some authority.
Yes,
So that he has delayed.
But-
So.
but it is a responsibility of the petitioner under the statute to produce
So,
the environmental
he-
clearance
Prior to the agreement or after the agreement?
after the agreement.
So if he has approached the authority took 28 months time to take a decision on granting a clearance, then what will happen? It has a limited duration. Is it?
Yes,
Then who can be responsible for this? They have approached promptly immediately after the lease is executed.
Yes.
give me a certificate, clearance. If they have not followed all the norms, you indicate that these are the lapses you have not followed, we can't grant you only to remedy.
Look, this matter, your lordship may.
Sir, I was absolutely against the principle of consideration of representation, but these are the cases where I find that those are necessary. If there is an ingenuine grievance, I can understand that unnecessarily is prolonging the litigation. These appears to be a genuine grievance. Has it been granted?
My lord, yes, everything has been granted and he is sitting over the matter since January. He will not allow me to operate.
What is this? Now the clearance has come.
Yes, I have annexed. I have annexed everything.
Yes. Directing him to take a decision on that.
But my lord, only 5 days are left. So far as 5 years are concerned, out of 5 years, I have only operated for about 2 years, 2 months.
They will have to take a decision for extension. Court cannot substitute.
That is true. That is true, my
Can
lord.
a court rewrite
Yes,
the agreement
they
of
have-
the parties?
They are
Cannot.
aware of that, but my lord,
So let them take a decision within a time frame.
so far as my lord, 5 days left, let them allow me to
That
operate
we
the
can-
mine.
we can. That means impliedly we are imposing upon them to continue. Yes.
Item number 8.
Within a week from the date of the matter.
My lord, with you.
Within a week from. What is this? This is the progress. Yes.
Item 9.
So the exceptional proceedings have been initiated by the jurisdictional assessing officer laws. Notice is
What is this?
particularly similar order, lordship, similar issue, lordship has considered. It's in the direction to the department has to take any further proceedings in connection with this impunity.
Relating to 148A.
Yes, ma'am.
Is not done in the manner in which faceless assessment is to be done.
My lord,
You're saying this about.
yes, ma'am. My lord, the department has already filed appeal, my lord. Department has already filed the appeal against the judgment of the Honorable Bombay High Court. The self is pending. So my submission.
Any stays were granted. Has it been admitted?
No, my lord, that is not been listed.
We simply keep it pending there. We have simply said that the matter will be listed along with that.
Item number,
Yes.
item 10.
This matter relates to non-constitutional institution.
Both the matters came up.
Yes, yes, yes.
Yeah, you can.
Yes.
Give me,
Yes, yes, ma'am. Yes, ma'am.
Yes.
Item 10. Item 11.
Item 11, your lordship is similar to item 9 and making necessary correction in the order.
Similar.
Yes.
Item number 12.
Item number 12.
Sure.
My lord.
As per.
Jurisdictional assessing officer, that is a dispute file. So that last time.
Why are not taking the manner in which section 151 is
Capital.
Capital A.
we should, now, by now, many cases are filed.
Yes, my.
So why the officers are not following that? You must be aware of that.
Yes, ma'am.
Now, what?
And that is a mandatory, I will proceed.
So why are your office not following that? That's what I am asking. Many cases.
The department is by the appeal.
Item 12.
Sure.
Item number 12, consolidation of multiple years in one. Sub item 1, 2, both is similar.
Yes. Next.
I will, file counter and.
Lead case, whether it has been filed or not, I have to verify.
Just do it. Yes.
Item number 13.
Item 13, Your Lordship, this is regarding in absence of the tribunal.
With the order.
Item 14.
Oh, bless you.
Yes.
Is not called.
Item.
Item 14, both the cases.
No, the first case I am approving, second is the state. Second is the second sub item is.
You think perfect copy. Rightly, I have number. Yes, yes.
Item number 15. Item number 15.
Okay. 16.
Item 16.
16 Lordship, RC cancellation.
Item number 17.
May I please, my lord?
My lord. My lord. My lord, first that order in original is given in by email. DRC 07 could not be uploaded.
Go to the tribunal.
My lord.
In the tribunal.
No, my lord, actually, pre-deposit, they have rejected on the pre-deposit ground and also on merits. Whereas I had given applications for depositing.
Second appeal.
My lord, pre-deposit technical ground, they have rejected.
What?
My lord,
The tribunal is not competent to set aside the order of the
my lord, that
appellate authority.
my lord, actually, that will be the principles
That
of.
will be.
My lord,
Then,
My lord.
what about the constitution-based decision of the Supreme Court in Chandra Kumar?
my lord,
On a tribunalization,
my lord.
if their forum has already been provided, then Article 226, 227 should be very strictly followed.
My lord had already considered two cases where pre-deposit not deposited and they rejected both on pre-deposit and on merits. In my case, they have I prayed for 3 times that please guide me in the offline case how I will
Perhaps now the circular has come
Well.
to file second appeal.
Well.
This is not in place?
Yes, yes.
My lord, recent case also my lord has given.
No, before these orders,
My lord.
that particular circular was not brought to the notice of the court. Because we perceive that there is no constitution of the tribunal, it's not functional, there is no provision for filing any appeal before the tribunal. No mechanism.
My lord,
So a person cannot be rendered remedialist, we said that we will decide it.
my lord, this-
Second, now they have come with the circular.
Well.
Now in the circular, they have said that if any matter pertaining to a particular year, they have given a timeline within which they can upload their appeal.
I bow
The
down.
petition has been extended for that.
But
So that right of appeal now has been recognized, you can file it.
Hello.
There is no difficulty.
my lord, there is
You
no.
can file it.
My lord, I bow down. I submit that. Here, they did not guide me to deposit the 10%. Rejected on the same ground. And now, if I go to the tribunal, even if I have merit in the case, I have to pay more. Therefore, they have done the natural principles violation, even if my applications were there.
Sir, had you deposited 10%?
My lord,
Had you deposited 10%?
my lord,
Then you
I
were entitled to have the appeal heard. Now your case is that this appeal has been decided both on the ground of non-compliance of the prerequisite deposit as well as on merit, you said.
My lord.
So the tribunal will decide what to do.
My lord, the difficulty here is that, my lord, the DRC 07 they did not upload, and
So can we go into again, I am saying, when there is an alternative forum which is
my lord,
provided?
in this case,
My
lord, in this case, my lord can go. Reason.
So you decided, so we'll decide here and now.
No, my lord.
And we can say that we do not find, if we come on merit,
No, my lord.
that your case does not
My
come.
lord, I have prayed not for merit. I have prayed for restoring the appeal because I am willing to pay the. I am already ready and willing to pay the 10%.
Correct. So now question is, there is a timeline within which it has to be paid.
My lord, actually,
There is already a period of limitation provided
Correct.
for filing an appeal within a time frame.
Yes.
Now tell me, can you
Yes.
deposit any amount beyond the outer cap?
My lord.
Can the authority pass an order?
My lord.
Can we also pass an order?
My lord. Law.
Baranagar.
My lord, law and technology.
Barasat. Recent judgment of the Supreme Court on Barasat Medical Hospital case.
My lord. Technically, law says first deposit 10%, and that this is already provided in the online filing. If a person goes for online filing, the 10% automatically gets deducted, and then only the filing is possible. In this case, because offline filing, he made a prayer that offline filing. So you please guide me where to, in which account to deposit. They did not guide him, and he also again made a prayer that my case be uploaded, the demand ID be there, so that I can pay the deposit. In both the case, in 3 applications he has given, they remain silent. And the law says if the pre-deposit is not given, then the rule 108 of the CJ says that appeal number cannot be issued. Appeal number cannot be issued means it is not filed. So this is a case where they have proceeded without jurisdiction in this matter. And now by rejecting, the RCC will be burdened with more pre-deposit rules. There is a violation of 107. They cannot go into the appeal hearing itself. My lord, I have submitted the rule at page number 9, minor. For the provisions of this rule, appeal shall be treated as filed only when the final acknowledgement indicating the appeal number is issued. So in my case, final acknowledgement indicating the appeal number is issued. Final acknowledgement I have given, my lord, in page number. The format is there at page number 80. So this demands that the authority should give the appeal number as per this final acknowledgement, then only they can go for merit hearing. In my case, even if law demands that pre-deposit is to be given, and I was ready and willing to pay deposit the pre-deposit of 10%, they did not provide the opportunity and compelled the hearing, and also rejected the appeal on the same technical ground. My applications are, my lord.
When is the impugn order?
My lord,
Is it 13 election 1? The impugn order is election 1.
Annexure 8, my lord.
Impugn order is?
Annexure 8. My lord, before traveling to the impugn order, I want to draw attention of my lord to the page number 50.
No, I understand. Let me see that how he has.
My lord, A3, A5, A6 are the things what the letters I have given for allowing me pre-deposit, allowing me to upload the DRC 07 and A6 also, my lord. I made a prayer.
To your appeal
My lord.
on the ground of technicality, but also that of merit.
My lord.
If you invite our attention to dispose of, then both we will decide and you will not be given any opportunity for second.
My lord,
Mr.
my lord.
We will not decide piecemeal.
My lord, I have,
Decide yours.
yes, my lord. I have only made a prayer in my prayer that I may be allowed.
Now, what is your decision, please tell.
Now, Mr. Patru, when we talk about this,
My lord,
an appeal or any list is decided,
my lord,
say, on 5 grounds.
my lord,
If one of the ground
my lord,
appears to be wrongly interpreted,
my lord,
but the other 4 grounds,
my lord,
if they lead to a same conclusion, it does not involve
my lord,
the interference and setting aside the whole of the order.
my lord,
What my brother indicated to you, I also indicated twice.
my lord.
You are more concerned with the non-deposit of temporary when you are citing our judgment that the authorities are waived, and therefore let us proceed that this ground is not sustainable. But if the authorities have also decided on merit, can we say that the order should go on that ground alone?
My lord,
If the merit does
yes, my lord,
not commence or I would say convince us.
my lord,
Then-
my humble prayer is, I made this prayer, I drafted the prayer only for remand back and deposit the restoring the appeal, my lord.
Can you command the bench
No,
that what you want?
No, I
If
cannot.
it is not a case of the remand, why we will remand you?
My lord, because,
Remanding means then we'll have to set aside the whole of the order. If we do not find any illegality and infirmity on the merit,
my lord,
why will we remand?
my lord, because the technical ground.
Maybe
My
it
lord.
is, if they have waived, suppose they have waived, they did not insist. Does it invalidate the entire order on merit?
My lord, I
So-
bow down and.
So merit you cannot say.
Well.
Simply on a technical ground, will it go?
My lord, my humble prayer is, because if the matter is hard.
If you say
So
that
two-
since you are
two
not,
statutory
you
remedies
are
will be
not,
lost, my lord.
if you do not deposit the 10%, it is not a competent proceeding.
My lord.
Let us decide.
My lord, on that ground
And
only I have made
and
prayer.
if we find that no, it can be, then there is no difficulty.
My lord, my humble prayer.
So that will foreclose
No, my lord, on merit I have not prayed.
your right of second appeal before the tribunal.
My lord, on merit I have not prayed.
Mr. Patron, you have to argue both.
My lord, I have not prayed for.
We will
Oh, you have not argued. Then let us decide. Then
My lord,
that ground, that waiver This cannot.
My lord, I bowed
No,
down.
no difficulty.
No, my lord, I prayed only for restoring the appeal because two statutory remedies are there for me. My lord, I pray for.
Now we'll decide that point. No difficulty. We'll decide that's only point. Say, no difficulty. Yes.
Item number 18.
Given for that about. My lord,
Everything. You can do it. No problem. Yes.
my lord, first appeal.
Next matter.
But
Item.
I want to avail first appeal and second appeal both.
I do not know. Your prayer is.
Mr. Patro,
My lord.
we will not relegate you to avail section 112 any further because you declined to argue on merit. You wanted only technical point to be decided. We will not interfere in that technical point. We will say that since you have not argued on merit, we are simply discussing your exception.
My lord, then I withdraw this case.
No, why will?
My lord, I
We
withdraw.
were avoiding.
My lord, I want to avail this statutory remedy, my lord, second appeal. My lord, my case may be considered.
And where is that supplement?
Also.
Oh, it's not required. You can.
These cases related to summary rejection also, not on merits.
Yes.
My lord, I pray for liberty for filing second appeal. Because my
You have chosen.
my lord, my lord, my prayer.
Zoom 25 minutes.
My lord.
Consume. We are restricting your prayer. We know it.
My lord.
We are deciding. Admittedly, the
That's the item.
My lord, my lord, there is a liberty may be given to seconds.
That's the item 18, the section 73, service statement.
Yes.
My lord.
Sub item also same.
Sign it.
Yes, 17th December is the date fixed for here.
Item 18.
Okay.
Item number 19.
The petitioner. The petitioner is filing this petition challenging the improved order dated 65/2005 passed in WTC before the 9th of 2003 by the Honorable Judge of this court. My lord, this order is specifically passed in absence of the petitioner who has been selected by the selecting authority by
In absence of,
the petitioner, my lord.
why you were arraigned as a party?
My lord, I was party there, but notice has been sent.
Was there, why you did not appear?
Sir, notice was sent to the petitioner.
Correct. So why you did not appear?
But out of ignorance, he could not.
Out of
Ignorance, he could not appear.
ignorance.
My-
Can an ignorance of law
my-
can
not
be a
a-
ground to set aside the order
My lord, set aside not only that,
or a good ground for condonation of delay also?
my lord, my lord, my respectful prayer is that, that is not the, that
You approached the single judge, convinced him that why you could not appear on the day when the matter was decided.
That's
If the learned single judge is convinced on the grounds, he will pass an order. Why
Yes.
you are coming in an appeal?
My lord, despite that ground, another ground is also there.
Yes.
My lord, the ground is that the petitioner was the residents of the place, but the opposite party.
You have not filed your pleading if those facts were not there. Can an appellate court enter into those facts
My lord, I was
for
not
the
there.
first time?
My lord, I was not there, so I cannot get an opportunity
If you
to
have inherited
So, your
the
lord,
asset,
review.
if you have
Allow me to,
inherited the asset, you should also bear the liability.
my lord, allow me to.
How can you?
Sir. First. Given an option, you could not take it. You could not understand what my lord has expressed.
Yes. So, am I allowed to file a review?
Huh?
Review, my lord.
Oh,
Before the launch.
I didn't know.
My lord, with your lordship will not say after appeal, you will not entertain. So, the lordship at least allow me to file.
Sir, your understanding is of a review.
Before or recall of the order, whatever you lordship.
I do not know why. We are not assuming or exercising the advisory jurisdiction.
Because,
It is up to you.
because my lord, I was not there. I was not
Sir,
there.
then take a call, what you want to say, decide. We will decide as an appellate court solely on the ground that whether this findings is wrong, illegal or not.
Yes, madam.
On the basis of the facts which was available to the learned judge.
Yes, madam.
If you can, if
It is
you
purpose-
can convince us that those facts which were there
It is.
does not justify this order, we are ready to hear.
My lord, it is perverse. I am just giving you,
Tell me why it is perverse, sir.
my lord. Your lordship kindly have a glance to annexure 6, that is the guidelines.
Yes,
Page 330, my lord.
yes. Whether this document was there before the trial court, I mean the single judge,
Yes, madam.
it was there.
It was there.
You take it that it was there.
Fine.
Yes. Guideline is?
Guidelines, eligibility criteria B, my lord.
Annexure,
Annexure 6, page 330.
is 29.
30, my lord.
Yes.
The other. Eligibility criteria, my lord.
Yes.
B. Your lordship come to B.
Correct.
In case of rural area, she must be a resident of the village.
Yeah.
And in case of the slum or one area, she must be the residents of ordinarily residing in the slum adjacent to slum area. I belongs to rural area, my lord.
Where he has admitted in the writ petition that you belong to a rural area?
Yes, my lord, that is
He has
admitted.
admitted.
It is admitted and the honorable single judge hold that
Let us see, then.
she must be a resident of ordinarily residing in the slum, so and so. BPL card. So the candidate who will be selected as Asa Karmi, she must be the residents of that village.
No difficulty, sir.
My lord. The logic now comes to the
Not village, it should be resident
Or-
residing in a slum or adjacent slum or a ward.
rural or urban, but I belong to rural
Rural, then you must be resident of the village.
village.
And in case of slum, urban area, then it's a different. You should be a village. Then
Village. The logic comes to the order passed by the honorable single judge that yes, Annexure 1.
yes.
Page 18, my lord. Page 18, para 9, my lord. Para 9. Para 9 is Assam Patel and AGA. On the other hand, would argue that the guidelines.
Just one minute.
My lord. I want to place thereafter page 20, my lord. Page 20, it is not disputed that the person was married. She claimed to have been separated from her husband and that she was residing in her father's house. The residence certificate issued in her favor by Tahsildar mentions that she is a resident of Moria village. Though it has been stated that the person having married is not a resident of the village, yet nothing specific has been mentioned in this regard. So my specific assumption with your lordship would be that the person who has been selected first, she does not belong to that village. So she is not entitled to be.
Why, tell me,
My-
what the guidelines says?
Guidelines.
Does it contemplate that a person, that the person who is married must live in her matrimonial house? Does it mandate?
Normally, sir, it is after marriage.
Normally, does not say, it does not so.
Sir,
If there is a matrimonial discord,
sir, it is not
if
also.
they are not,
No, sir, matrimonial dispute.
if they are not in harmony, if she is living with her parents and there is a proceeding for divorce going on, unless the degree for divorce is granted, she will be regarded as a married woman. If she complies these conditions, can you say that, where is the condition in the guideline? Guideline does not say so.
Guidelines will also not equally say that after marriage, she will be the residents of that village.
No, that's why I say, so the learned single judges correctly assess. That first thing is the education qualification, and second thing is that she should be married. And must be resident of that particular area, rural area.
My lord, here
So
I
see,
will
he has
dispute that.
said that since he has submitted the certificate issued by the villagers that she is residing in her parental house, there is no
But two
harmony in the matrimonial house. There is a proceeding for divorce is continuing. She is residing elsewhere, as she is residing with her parents, so she can be regarded as a married woman. So long the divorce is not granted, and she is a resident of this.
But her argument should not be in twofold, my lord. Divorce, she has given an affidavit. But she has given an affidavit before the selecting authority. To identify.
Say, I know. So, I think what's he saying?
But her marriage, she has given an affidavit. He has already divorced, and she could not produce his divorce order within due time also. That is also considered by the selecting authority, man.
No, she was married on the date when she offered the candidate.
Married. She was by that time she was married, and also
That's not,
equally.
it is the criteria must be judged on the basis on the date when she submitted her candidature, not beyond that.
So, my lord, one thing I can want to submit here that she got married to somewhere, and he belongs to the father's house. So, from which residence he will be?
Sir, you are a very responsible member of the legal fraternity in the society. Have you not come across many cases where, because of, may I say, disharmony in the matrimonial house, the girl comes to the parents' house and live. Divorce proceedings takes a longer time. If you are engaged, you know this procedure. So long the degree of dissolving the marriage is passed, she will be regarded as a married woman. She cannot change her status. Just wait for some minutes. Yes.
Item 20.
Document. And another. Document and another one. While working, national insurance company had a request before the honorable senators for change of inquiry.
Now change me, what was the allegation?
You know,
What was the allegation?
in the
It was a financial embezzlement or something else?
the allegation was that the opponent, while performing his official duties, has acted in a manner prejudicial to the interest of the company, have been ignored the instruction, even the advisory.
Does it cause any financial?
No, my lord. I have mentioned the claim was settled, no loss was caused to the corporation.
There was a financial embezzlement.
No, man.
What else? No losses caused, you have said.
I have mentioned, my lord.
Where is the article of charges?
My article of charges is Annex 1. Page 19, man.
Yes. Page
Page 19.
21.
Serial 1, my lord.
Just. Second charge is, sir.
Lordship rightly point out, my lord. In my
Normally, in absence of any rule, the disciplinary proceeding will not continue after the attainment of the superannuation if it does not cause any financial loss to the employer.
Mine, the lordship right.
But if it causes the financial the loss, then it may continue. There is no difficulty.
My lord, I have mentioned.
You are making out a case of such motion.
I have mentioned in my lord.
Now tell me whether the second charges have been found against you by the inquiry officer or a disciplinary authority. Tell me.
My lord, in the repetition, we have prayed. I have prayed. The appellant prayed for change of inquiry officer. And
no, you have prayed for discontinuance of the inquiry after you attend superannuation. That's your prayer.
That is one ground, my lord.
That is the only prayer, sir.
And another, my lord, prayer was
setting aside the order and declare the continuance of the disciplinary proceeding after retirement.
That is
not permissible.
My lord, that is one of the prayer you lost right.
No, sir. This is come to page 18. Sir, don't argue at the bar.
Why?
You should restrict to your pleading.
Pleadings, my lord, I have
Please. What you have said,
No,
setting aside the order and declaration that the proceeding cannot continue.
My lord, what I humble submit, my lord, this is one of the points you are also writing pointed out. My lord, what I humble submit, before the honorable single judge, my prayer was to change the inquiry officer on the ground that, my lord, on the ground that.
Where is the prayer in the writ?
My lord. May I read now? The petitioner therefore most humbly prays that you not
Prayer of the writ.
read my lord. 10,520 of 22. Page 17, my lord. The petitioner therefore most humbly prays that your lordship will be basis in peace to receive will necessary colleague of the opposite parties to cause as to why the order dated 24/2022 at Annex 16 refusing to change the inquiry officer should not be passed and as to why opposite parties should not directly change the inquiry officer and according to impact to conduct the inquiry by setting aside passing the order's function. One order is made non-supply of documents and closing the inquiry expert.
This has been done. So this has been done. You have been permitted to appear before the.
My lord,
inquiry. What do you mean?
My lord, limited prayer is documents were not supplied despite and the defense witness was not called.
What is cause?
Only my lord, limited prayer. Remitted back. Remitted back only is a limited prayer. Man. Let the inquiry officer to supply the documents, my lord.
Sorry.
Supply the documents.
Sorry.
And the witness was not a minor despite my request.
This is of this. Dismiss.
Item 21.
Looking for the cabinet or copy of a repeat service also. It a female, sir.
You just right now.
My knowledge friend also.
What?
I'm storing the copy.
21.
Yes, please.
Why have you lost the caveat?
Yes, ma'am.
It is there.
Very
We find that the caveat has been lost in the instance.
Item 22.
Okay, can you just solve it with copy number? Lordship calls this any day this week,
Item 22.
Sheffield. She against order dated 13/7/2025. As my honorable she results. Has been rejecting my this application. Lordship, page 47, Lordship starts from page 47, annex of 1. It starts from page 47, Lordship. Hearing Lordship 11/7/25, then judgment 10, 13/10.
Taking a plea, have you brought the judgment of the Supreme Court?
In fact, Lordship,
You have not.
but on merits, that is a one ground, Lordship, the judgment I have not.
That is the only ground. If you have taken that ground, will you not bring the judgment of the Supreme Court in this regard?
Lordship, in fact, that is there, Lordship, have taken that ground. But we
Why
don't
will
know.
not come with the judgment, sir? You are supposed to assist the court.
That's true, Lordship.
The court is not supposed to find out on the judgment from you.
Lordship, little mistake, Lordship, file is misplaced, Lordship, that's why I was some.
Why is misplaced? Then tell me what are the judgments?
Lordship, in fact, one,
Tell me when you took this plea, tell me what are the judgments?
the one of the grounds, Lordship.
No, tell me what are the judgments of the Supreme Court?
Let's see.
Day after tomorrow. Bring a judgment of Anil Rai
Lordship,
of 2001. Bring that judgment.
Lordship,
Bring also the judgment of RAMAN subsequently delivered.
Lordship,
Bring that judgment
Lordship.
and bring the judgment of the recent judgment of
Recent judgment, Lordship.
Supreme Court.
Supreme Court, Lordship.
Bring.
Lordship, grateful, Lordship.
Item 23.
In 23, my lord, this leads to that initial matter, my lord. Let's say pray for 7 days time. In the meantime, the measurement is going on, my lord. They are trying to. Great.
Item 24.
Here I have received the parawise comments. So may grant me a week's time, they file the affidavit.
Completion by a week, rejoinder by 1 week, 2 weeks, please.
Item 25.
Wait, please. Lordship, this is the PIL. And petitioner sir cabins the action of the opposite parties is not developing and promoting the Chomuk Dada page. Even though in the year 1998, the Department of Tourism had identified and recognized this page as a potential place of tourist interest. On the last occasion, your lordship had directed the Lord and Government Council to take instruction.
Yes.
Let the instruction have seen. In the meantime, the demarcation of the land is being done here, and the construction will start with sugar.
Your purpose is over. The instant repetition of the nature of the public interest petition is taken up.
Yes, madam. They will anything next week, madam. They got the.
Item 27.
Here we are, all three intimations which are assigned for also with this petition, that's an intimation. That's requiring the petitioner to pay interest on 7/5. The lordship has seen the other day, the calculation had annexed to 8 bills that contains apparent errors bills. The lordship directed Mr. Mishra bills, and in the meantime, in the last occasion, Mr. Mishra has handed me over one statement rectifying the interest from 2 crore 63 to 2 crore 46 to 2 crore 41 crore 63. And the basic thing which left still unanswered, your lordship the other day virtually started dictating the order that neither in upper, it's a matter of 2018, 17 years after mirrors, they are imposing interest mirrors without granting any opportunity mirrors, without issuing show cause, without soliciting reply. By intimation, they are demanding 7/5 interest. Particularly when this Supreme Court, by judgment in Sri Bharat Motors, have held that so far as 7/5 interest is concerned, not pending litigation before the Honorable Supreme Court, it is not imposable. But so far as there are two interests your lordship have taken care of. 7/5 not imposable, and so far as till the date of judgment from the date of alleged default, it is to be paid compensatory interest of 9%. And all the matters are pending before the Honorable Apex Court years. Though judgment is stayed, your lordship said that operation of this judgment cannot be to be handled. So whereas under these circumstances, the only limited prayer which I am making your lordship, the order which your lordship proposed the other day, that will be passed. Let the officer concerned give opportunity. Whereas I will reply to the notice. 7/5 not a matter of course. 7/5 contains without certain contingencies to be satisfied. One is whereas if any amount is found due on the basis of the return filed, if not paid, of no returns filed. If those contingencies satisfied, then only one will go for imposing interest bills. So here, and other rider is sufficient cost. The provision starts from unless there is sufficient cost. If there is mere non-payment, will not entail interest unless there is sufficient cost to establish the willful default in not paying the tax. So all these requires adjudication. In many cases where I have come across, they pass orders either we choose to pay or file appeal. So here is a case by intimation without passing any order, without giving any opportunity, all three communications which are assured lordship, they have intimated to make payment of 7/5 interest. So that is my only limited bills for lordship bills.
Your lordship, only one line submission, your lordship, against my learned senior. So far as that sufficient cause is concerned, your lordship, sufficient as have been held in Sri Bharat Motors case, your lordship. The Honorable in the Sri Bharat Motors case in 2010, the interim order of Honorable Supreme Court has passed. So from 2017, the SLP has been disposed of, your lordship. From 2010 to 2017, my lord, this Honorable Court has directed a compensatory interest and has decided that there is sufficient cause since Honorable Supreme Court has directed the interim order to pay 1/3. Here, your let's say, Honorable Supreme Court has passed the interim order on only one line on 9/4/2013.
He has submitted.
That is only one line submission.
Point.
My lord.
Whether you will afford him a reasonable.
Only one line submission, my lord.
Or not.
My total interest is 1 crore 63 lakhs. Out of that, in 2012. I'm not repeating your lordship. Only my respectful submission.
Please.
I appreciate it was placed before us on the earlier officer compulsory.
No, I'm not on time. I'm even accepted for a moment.
This expressions were coined, I do not know from where.
Even accepted for a moment, the pendency before Honorable Supreme Court, accepted for a moment. The pendency.
He's saying they're not,
You're not
provide them you are not done. Straight away you went. And you also point that there is some mistake which is there also in the condition. That really shows all these composite facts that if he is given an opportunity, he may place before the authority. What is the harm in that? What
You're not
say that he will not ask for an adjournment, we can put an inspection conditions. He will not ask for an adjournment.
Your Lordship,
Do not write a letter, give me 30 days time, old records I do not have. Give me 30 days time to collect. They will not grant them a time.
Your Lordship may fix up a date, let him appear before the authority if he has anything to say. Your Lordship, may please.
That is what, nothing more than that.
Your Lordship.
It so happens that after that, the authority may bound the further amount.
Your Lordship, only my anxiety for submission, the 90% of interest is prior to Supreme Court. Prior to interest. Your Lordship.
Let's agree.
But that out of 1,64, only 23 lakhs is the interest from.
Anxiety this side.
Your Lordship. Your Lordship may fix up a date. Your Lordship, let him appear before the authority. Your Lordship, and
Yes. Within 1 month and you will not ask for anything.
My-
Right? Dispose of the matter within a month
Your Lordship.
and will not grant anything.
Your Lordship.
Here, that's a 1 month assurance from his son.
My,
Your
If
Lordship.
it what permits or remands, then he assures the authority will decide the matter within 1 month. Provided you do not ask for any adjournment or remand.
will not.
On Yes.
Item 28.
Single judge. That dismissed petition on the ground of alternative remedies available.
Because at the hearing is still or at the decision is still.
Here it is.
Affidavits were complete.
Matter?
Affidavits were complete.
Yes, leading is complete.
There,
There
the
before the
petition, the pleadings were complete.
yes, my lord.
And you are detecting gender. What is going on? The allegation against you is very serious. Gender detection. You know it's cascading effect.
One case.
All these machines were seized from you.
Yes.
Yes, so easy.
2013 it has been seized, it has not been released.
Will not be released, confiscated and what are you doing? You are really doing, do not know what word should be used for that. There is already a prohibition that nobody will be permitted to detect the gender.
Yes, my lord. Yes, my lord, your lordship is absolutely correct.
And
That is not the case of mine.
and you are doing it.
No, my lord.
What
It's not a case.
Documents have been seized.
It's not a case that, my lord, one thing is that
You know,
the CDMO,
the only thing is, the problem is that what troubles me, if there are judgments of the apex court, it says, that if you want to dismiss the writ petition on the ground of alternative remedy, then it should be done at the very threshold. But once you invited the parties to exchange the pleadings, then in that event, dismissal on that ground is not permissible. You have to decide it on merit. Reject, no difficulty. But decide on merit.
but here only he has remanded, he has not.
Remanded where?
The same authority?
No, no.
No, my lord.
Says that the appeal is under section 21.
Six.
Para 6, this is the appropriate authority under section 21. This is he should approach. Mr. Das, no, it's not. Dismissal was unwarranted.
Dismissal, my lord, by the appellate authority, against the appellate authority, the honorable court has directed. Yes, that
This cannot be done, sir.
he should not have said writ petition is
Correct.
dismissed. That para 7 maybe.
So paragraph, right, the last sentence, that he could have approached the authority under section 21.
Yes.
Having not approached and approached the writ, hence dismissed. That means
Correct.
alternative remedy. That cannot be.
But that dismissal, that word dismissal itself
No,
should not have been
the
there.
dismissal is, if you come to paragraph 5 of the.
5 have gone,
impute paragraph,
that is
last
the
line.
submission by
But
the
the
state.
state authority dismissed the petitioner's appeal against which he should have
Approach the state.
approached the state government
Under
under
section
section 21. That's the alternative remedy was there.
Yes.
Then is a considering the submission of and going through, the court finds that in the present case, he has not approached the appropriate authority under 21. Within the prescribed time, state has approached this writ court, which is not maintainable. Why? Maintainable is there. That means there is alternative ground here. And that this cannot be done after exchange of reference. He could have done it at the threshold. First time moved, reward him back.
But here the state, I think, has not filed any counter. In this case only.
Yes, state and file counter. Yes, state and file counter.
Mr. Your petition was never admitted.
No,
It was
counter affidavit.
It's counter has been filed. I don't here is the counter. Here is the counter. Is the counter. Personal appearance was made.
Personal appearance was there. The
Personal
PDMO
appearance
was-
was
Counter
made.
affidavit by opposite party number 24.
That is not
Recording.
it is November 2024.
7/8/2024 you filed additional government advocate.
Yes.
So. Could not have. That should not happen. Yeah.
So lordship,
Yes.
lordship, and they have a glance to section 30 of the act. But there's the power with respect to search and seizure of the records. Now, if your lordship may kindly see sub-rule 2. Sub-rule 2, the provisions of Code of Criminal Procedures
Sir,
relating to.
everything that the court would have written this.
Yes.
And then could have done, but he has not done it. Yes. Yes. Good. Yes, next.
Well. Item number 29.
On behalf of my colleagues, I want to seek an adjournment. My name is now should not be. My name is
Let him recover.
This one.
Well.
What last one?
Item number 30.
He's the role of the hearing matter.
No, these are for orders. We are in coordination of the.
What?
Item 30.
Item second list was heard, it was for moderation.
No, sir.
Oh, then you have to, who is appealing?
I'm okay.
You argued.
Mr. Ratha had argued with us.
Can you bring him?
You will come with us, or else I can assist you. I can assist you.
Can you bring him just to, because there are certain issues which he has argued. Wanted to have.
Yes, sir.
Clarification.
Yes, sir. He is arguing in a different court. He is on his way. I'll bring.
Tell him, just request him to come.
Yes.
One.
Item 31. This guys.
The Lordship, we have filed a joint petition compromise.
This matter, speak. Why compromise?
It is the Rahul Kela, my lord.
Smart city.
Smart city.
No, you write down.
31.
31 is the Credence Interior Private Limited.
IAPF for credence.
And it is against the state of Odisha.
No, the contesting party is the smart city man.
The state who is representing. You are not party to agreement. Some of the parties to a proceeding has compromised, then what? Can it be done?
Then your
What is the grievance, main grievance?
grievance was, my lord, ignoring my tender to tender, they allotted it to someone else, though I was the highest.
Okay, now what is the compromise?
Compromise is well, that we have decided they will, in fact, that is out
They
of,
will pay you something.
that is out of court, they will refund my forfeiture of security and all that. That is out of court again, that is not recorded.
Then?
And I don't want to proceed with the matter.
Oh, you do not want to proceed.
Yes, sir.
It's not compromise, so we are not recording anything. You have not entered into an agreement,
No,
written.
no. That is what the
He
deal
does
allow.
not want to proceed. That's the understanding. The senior counsel appearing for the petitioner submits for the instruction. your submission so that they cannot reside. Yes.
32.
What?
Your Lordship had heard this matter earlier, my lord.
Can you come on that? Let me.
On the other day, your lordships have heard this matter at length.
Can we fix it on day after tomorrow?
As you want.
Day after tomorrow? Mr.
Mr.
Gadodia? Day after tomorrow?
Yes, my lord, no problem, my lord. Day after tomorrow.
Not audible.
You're not audible.
My lord, no problem, my lord. I'm sorry. No problem.
No, 100%. Our system. It's day after tomorrow, Mr. Gadodia.
Okay, my lord.
He's with you, coming in form. Yes.
Item 33.
In this matter, we are filing counter affidavit tomorrow on that. But that is.
File counter affidavit tomorrow.
No, we'll file tomorrow.
Oh, you said we filed counter affidavit tomorrow. So when you use the past tense for tomorrow, that really creates a confusion.
My lord, there is a noting in the lease pillar. They have not.
Don't go by a noting. You want to file it tomorrow? Who is for the petitioner?
Miss.
Sir, Your Lordship, I'm the proxy counsel for the petitioner. Mr. Matthews is in a personal difficulty, so I'm seeking an adjournment on his behalf.
What you want?
Have you furnished the notice? Requisites for issue of notice as directed on.
You are for opposite party number 3.
No, my lord. Opposite party number 3 is the private party. Notice.
Have you filed the requisites or put in the requisites?
Ms. Khatri.
My lords, I'm actually a proxy counsel. I'm not aware of this. I'll have to consult the main counsel. He's having a personal difficulty. His mother-in-law was hospitalized this morning. So he told me to seek an adjournment on his behalf. I'm not aware of this.
Adjourn for 2 weeks.
Item 34.
Much obliged.
On the ground. We have to wait for.
In this matter,
Condonation of how many days?
delay of 14 days, notice your lordship have issued on the earlier occasion. And now put a press code number 4.
14 days delay. Delay. And put the matter in the next week.
Yes. Item 35.
Reasons was shown in the
Next week.
petition.
Can it be?
We condone the delay. It will come on next week, Monday.
Sir, copy.
Yes, ma'am. May I say, ma'am, can it be a week after?
Oh, it's
2 weeks. Yeah.
Item 35.
35, my lord, I have instructions to appear on behalf of Paradip Port Trust, my lord.
Who is the delay? What is the delay?
In fact, Lordship, 180 days. But Lordship, all are senior citizens and they are fighting.
What do you say about the delay application?
But I leave it to lordships, my lord.
Yes.
That's
3 and 4
59 days.
have not come.
Oh, the 3 and 4, who is appearing?
I am for office party of 3, my lord, Paradip Port Trust.
Okay. And 4, who is he?
Level commission of Lordship appeals.
When it is issued? Service?
PXL Central.
Lordships issued notice on 14/10/2025.
14?
10/2025, my lord.
Mr.
20th. Then the difficulty is that we cannot presume due service unless 1 month expires. So far as you are concerned, you have received no problem. But
Lordship.
so far as 4 is concerned, we cannot presume the good service. But because the acknowledgement due card has not returned, we cannot.
So thus you are appealing for Paradip Port Trust.
Yes, my lord.
1 and 2. 1
My
and
lord,
2.
Paradip, I am
Three.
yet
He is
I am
appearing
yet
for
to
3.
receive the 3 only.
3.
3 is Ministry of Transport and
My
Service.
lord, I am yet to get a copy of the appeal memo, my lord.
Mr. Bhavai, Please see. Your response, you have made 1 and 2 Paradip Ports Trust as respondent number 1 and 2. Then three is Ministry of Transport. 4 is Labor Commissioner, Chief Labor Commissioner. 5 is Regional Labor Commissioner. They are all union. Where are they? Have you served copy on them?
The notice has gone and it's not copy also. Let me know next week if you want copy.
So can't you appear for Paradip Port Trust?
My lord, I appear for Paradip Port Trust.
So then you are appearing for 1 and 2, not 3.
Yes, 1 and 2. I'm sorry, my lord, yet to get a copy of the appeal memo. I'm sorry for that.
Yes, give him a copy. Record his name. You will file a Vokalandama?
Yes, my lord. Within 4 working days, my lord.
Yes, Mr. E.P. Das appears and submits that he has instruction to appear on behalf of the
I can appear. Can I stop the?
This is up to, I have directed him Port Trust, and if you want to serve the Union of India, you can serve.
Let's write some.
Yes.
Item 36.
Service on other, the Union of India in the office of the DSG.
Let's see. 3, 4, 5. All 3 can appear.
No.
We are waiting for the postal articles to come back.
3, 4.
You have put in requisites for service of notice.
I also central government. I also.
You serve the DSG for 5.
Plus.
You 5, you serve 5 or 6?
No, 5 plus.
So DSG for 5. 3 and 4 it has gone, so we cannot say anything.
Plus.
If they come and say I am appearing 3,
Plus.
4, we'll consider.
Plus.
Don't. 36.
Item 36.
Will take this step in the correspondence.
Return answer. Addressee does not reside in the village. Not only in the house, but in the village. Just imagine. What village you have given?
That was the same. That address was given by the petitioner in the late petition.
Any advocate who was representing him? Can you call him?
I will.
Go and call him. We will direct him to accept the service. Who appeared for them? Call him. He is here or somewhere else?
Yes, got it.
Next
So Swam Prabhu
Monday.
must be there.
Yes.
Monday.
Swam Prabhu
Item
will be-
37. Item not 37.
And I'm here for the Orissa Absolution Commission with docking here.
Condonation, how much days delay?
27 days. 27.
27. Yes.
That's a reasonable.
Yes. For admission in the next week, Monday.
Right. Item 38.
Condonation and our.
Waiting for the respondents. The lordships file your order dated, the last order, order dated 29/2025. Lordship has been pleased to stay the order of the single judgment. But I've already filed an IA for vacation of stay, and I've also filed a counter and I've given the copies there.
So do you like to file counter to the vacating application? Fine.
The difficulty.
You know.
No, my lord, I'll tell you, my lord, I filed it on 27. And my lord, I failed in my.
Is he not entitled to file a counter to the vacating application?
So am I to pray before your lordship about my impediment, my lord. My lord, the problem today is, my lord, your lordship, I failed last appeal.
Do you like to file rejoinder to the counter which they have filed?
Was not only given a file.
Counter has not been given. What are you saying?
Given.
Where?
I've got a receipt. Vacation of stay and counter, both have been filed and served.
In an appeal, there could not have been any counter.
I completely follow.
What?
In an appeal, there could not have been any counter.
If they have decided to file a counter, then what is there? If you want to file a rejoinder, you have a right. A right is accrued because of him. So what can be done?
I'll file. Lord, one mistake I have done, Lord. The Lordship had asked me to take notice against the bank. That is OP number 4. OP number 2, my lord. That is Canada Bank, that they claim to have taken finance from. My lord, the order was passed on 22/9, around 26/9. I underwent an RE operation, my lord. I complied all the order, but I could miss that part of the oversight. I have filed the requisite, my lord, on 29/10/25.
I am from the Canada Bank.
Yes, that is right.
I filed the proposal. My name is already reflected.
I'll give you my copy, my lord.
But may I only state my predicament, my lord, to your lordships?
We'll hear out the appeal when.
That's my.
No, I understood. The moment you filed a vacating application.
I could not present my case last occasion, my lord, on BC. So I
No, you'll have to. You will have more difficult task to argue.
I'll try,
Definitely,
I'll
you
try and rise
argue.
up to the challenge, but so if date may be fixed, my lord, I'll try my best.
Next week, Tuesday. Next week, Tuesday.
I'll reply in the mail.
My lord, if I may, my lord, at the top of the list, to blame, my lord.
We are moving now. Nowadays, I have just changed the entire thing, fresh matters, so that it can.
In fact, my lord, for the past 3 days, your lordship was speaking of all of that.
Yes.
Item 13. Notice against Propi 2 may be held sufficient because he has already.
Yes, record that he has already appeared. Waves, service has been done. You received the copy. Give him a copy.
I'll give him. I had offered him a copy. He did not take.
Give your name.
Already in list, my lord.
Item 39.
Service.
Service.
Service. No. This is a condonation application is there. How many days delay? But he has a right. You have to serve a copy on them, on the branch manager in the IndusInd Bank. Have you served?
Yes, ma'am.
Very? No. Huh?
Notice issue on 22nd October.
It has not come back.
Yes, please.
Has he put in the requisites?
These ready there.
Has he put in the requisites?
Requisites to notice of an issue.
And the acknowledgement document, let's see, contains the seal.
That. Okay.
When? No. Yeah, we have received back on 28th of 10. 24.
This is
24 is the service, huh?
This is Anderson Bank.
Indus Bank. See, I've seen that.
It is,
How many days delay?
2 days, man. 2 days.
Returned. There is no
But
appearance.
he has
Yes.
records were filed by the petitioner. Huh? The notice has been served on this Anderson Bank. Opposite party number, the respondent number.
This is only one. The branch.
First one. It is on record.
Next week for admission.
It deemed it is treated to be sufficient. If none has put in appearance today. Next.
The last application for a small error has created. My lord, I am appearing for the writ petitions, my lord. So, but my name is reflected for the other side, but I am appearing for the writ petitions, my lord.
Wait, who is for the respondent?
Respondent, my lord, the respondent in the would be, my lord, Satyasundar Mahanti was appearing.
Where is the certified copy?
It's here, my lord. They'll give it in the office. We'll give it.
Just now he was there. Just now he was there. Just 2 matters before. Mr. Mahanti was there.
Yes, Mahanti.
Exactly.
Yes.
You may see that order friendly.
What order you challenged in the writ?
The order, my lord, we have come before the court. My lord, in the order, my lord.
Who filed the writ petition? I mean, advocate.
Opposite party filed the writ petition. The opposite party, my lord, filed the writ petition. They were the writ petitioners before the.
Correct. They were the writ petitioner, opposite party. Then why you have come?
I have come because, my lord, what has happened, they withdraw the writ application. Still after the withdrawal of the writ petition, my lord, the interim order was passed. May see the order for him.
Right.
No.
Right.
No. The civil suit arising from a civil suit, Order 7, Rule 11 application is filed for rejection of the claim.
Hello, Mr. This is
Satyasundar Mahanti.
Here.
He was there.
He was there.
Call him. Call him.
My lord, another thing that has happened.
Nothing has happened. Call him. Are you there in the matter? Can you appear?
Right, 240, I was appearing in the WPC, my lord.
That's true. Can you appear in the WA as well?
My lord, I have not got instruction, my lord, if your lordship.
Can you take an instruction? We are fixing this matter tomorrow.
My lord, I'll take instruction.
Take instruction. Keep this matter tomorrow as the first matter.
Right.
Take instruction. Please.
Item 41.
So there are some order of lords because matter is settled. I will approach you with the authorities first.
Yes. Huh?
In the other case you can, no, in other case you can. That other case.
Other case I will.
You just inform him.
Item 42.
Who? You are appearing for who? Oh, there is only one opposite party. But there are many opposite parties. It says opposite party number 4. Then whom you are appearing? 1, 2 or what? How many opposite parties are there? This indicates opposite party number 4 is returned. How many opposite parties?
There are 4 opposite parties.
Because I find from the note, neither the ED nor undelivered notice returned from opposite party number 4.
Mr. Mukherjee, you are for.
Item delivered. Track report says item.
The petition.
Petition.
Yes.
And you are for?
Corporation.
For all the opposite.
No, 4 is private.
No, 4, the item is delivered.
4
item is delivered. You are appearing for corporation. 1, 2, 3. Yes. What do you say?
Who is your senior? Who is empaneled there? Whom are you representing?
He is representing the corporation.
Mr. Susan Kumar.
That you said. Susan Kumar Naik.
Susan Kumar.
My difficulty is that this matter on the previous occasion when it was listed, I mentioned this matter because of the urgency involved. Well,
That's why from the next week, Mr. Mukherjee, I have decided that we will be passing an instruction. No mentioning will be allowed at the first sitting of the court unless you give a notice to the other side. The difficulty is because you can come and mention the matter. The moment the matter is listed, now you understand. The reasons are obvious. That's the whole difficulty.
as per her prayer, if it can be taken up tomorrow, she is praying for tomorrow, can be taken up tomorrow. Tomorrow.
On the prayer, day after tomorrow. Give you one more day. But come ready, no further adjournment.
Item 43.
In this matter, we have received the Parawai's instruction, Miller, the 2 days time to file counter appeal.
Who is Mr.
43.
Haripoto Mohanty?
Madam, I am appearing through actual mind. On last occasion, Learned Counsel for the state has taken time to file counter appeal.
Yes. So he wanted an extension of time.
My lord.
Yes.
Short date, my lord. Play for a
Yes.
short.
How much? 1 week?
Yes, ma'am.
To file the counter affidavit, but 1 week, rejoinder 1 week, 2 weeks since. Next,
Item 44.
in both the matters? Ajay, 44 is, yes.
Password, short password.
Why?
44, my lord. First matter, I have received the Parawise comments from OP number 4. The Tahsildar Bonai. Your lordship may grant me 2 weeks time, I'll file in the meantime.
Give him. Yes.
Item 45.
Right. 45 the three connected matters. First matter they have filed counter. Served last week and filed a rejoinder. I'm concerned with the first one.
You want to file rejoinder?
I'm fine.
Yes, brother.
Mr. Honorable, raise for filing. Result the counter.
Item 46.
46 may be permitted through virtual mode. The railway has taken time to file counter. Madam.
Mr. Padi.
My lord.
Yes.
My lord, on the last occasion, railway has been issued with the notice.
Mr. Kashyap.
My lord, a little short time. In fact, I have already sought for instruction and it is awaiting the short time, 7 days time, Your Lordship, I'll file my reply in the meantime.
My lord, I pray short time because it's a tender matter and they are proceeding with the finalization.
No finalization because in the meantime, OP number 3 has been noticed, returned unserved. Only 7 days time. Any day next week, Your Lordship, I have kept it.
What about OP number 3? Postal
The
remark.
noting is
Yes.
notice unserved.
Mr. Padi.
My lord, I will take fresh notice.
Fresh steps. Fresh
My
steps for OP number 3.
Yes.
Mr. Padi, it is shall take steps. Fresh steps.
47.
Obliged.
Corporation is appearing now.
No, what about it says that OP number 2? No from the information found. Is this?
I think 1 and 2 were the appearing, Mr. is appearing. The corporation, Civil Supplies Corporation.
Who?
Mr. Samir Kumar, Samir Mr.
But he's not here. Oh, nobody's replying. Well, who are you? You are what?
OP number 3 is successful.
You want to file what?
Reply to the requisition, I have to file the counter affidavit within 7 days. Today is the first date of the application.
Give him 1 week time. Rejoinder 3 days. After 40.
What the matter? Same question.
Item 48.
See, supply corporation non appeal.
Will you take a longer time to argue?
Well, we above simplified.
30 minutes. Composite. Composite, all of you.
My argument will be roughly 30 minutes. So I won't take much time. I know this, if your lordship recollects, there is one division bench judgment which has said that a doctrine of least pendants would apply.
Oh, this is that matter.
Yes.
In a contractual matter.
Yes. So the question is whether that doctrine can be en bloc applied to tender matters.
So because that section 52 talks about the immovable
property, but the principle has been extended to tender matters also by this honorable
Two
court.
judgments of this court was cited.
Yes, plus the
And,
Himachal
and,
Pradesh High Court.
Himachal.
We have got
Any other
judgments of
judgment any other judgment from
Delhi High
Supreme
Court.
Court or from the English law? Can you find out any judgment disputes?
I have made it simplified for your lordship. Page 460, there is a short note which I have given where there is a 2005 Supreme Court judgment which says that it has to be immovable property. And thereafter, there are, in fact, the judgment which your lordships have taken note, that also says in paragraph 46.
Where is the 2005 judgment?
Well, that would be at page 460 of your lordships. And the PDF, the exact paragraph of your lordships wants, it would be at page 466. 466.
This is for this Amit Kumar Shaw.
Amit Kumar Shaw, paragraph 50.
Farida Khatun.
Yes. That is being taken note of till today, it is approved. Now, your lordship may see paragraph 15. And just towards the middle, it says, if I can place that.
Placetum ward, paragraph 15.
It would be at page 411.
Placetum A, B, C, in between what?
No, I am reading from the judgment itself.
Yes, judgment I am looking at. Paragraph 15 you are saying.
Yes, 1-5.
B.
Yes, I understand.
It says that in order to constitute a lis pendens,
yes,
the following elements must be present.
Yes.
And what would be relevant?
Page 14 as you mark.
That is a placetum A and B in between.
Yes.
So it essentially should emanate from suit.
Suit is one.
Or a proceedings. Whatever it says, proceeding competent.
Facing PDF page 474.
But
and it would be internal page 14 of my note.
Yes.
What paragraph?
It's a
There must be a transfer of or otherwise.
No, that
dealing
is
with the
5
property.
conditions have been imposed.
Correct, madam.
I understand that I got it.
3 and 4 would be relevant.
Anyhow.
Then para 16, doctrine of lis pendens.
So what
applies only where?
What would be crucial, my lord, is that the litigation must be one in which right to immovable property is directly and specifically impaired. And next this, there must be a transfer. 3.
But para 16 list must
yes, then they go on to explain what is those are additional conditions. But this 3 and 4, subsequently, this has been laid down on a number of occasions. Your lordships would see, we are giving those judgments also. 2005, I showed your lordship paragraph 15 that 3 and 4 would be important. Then, my lord, 2024 SCC online SC 3214, which was relied by the petitioner. That, my lord's para 46 of that. Also lays down, also approves this judgment in the case of Amit Kumar Shaw, and recent judgment also I am giving. 2024 SCC online 3727. Paragraph number 155, they begin. What exactly is the doctrine? (155) that would be letters are there.
ऑफिस का भी नहीं कितना का पेज
Hope my lord got that. Para 155.
Record office का भी नहीं
Wherein they explain the term this many. What would be crucial would be paragraph 158. So linked to property, para 55 mentions property. In 158, they again read that.
It is what it is on the very first day when the senior counsel took that thing. So, and then he cited the judgments. There also I showed my some kind of a dissent.
Yes.
That you just because this concept of this list pendants actually originated from a common law principles.
Yes.
And then it is imbibed into the Transfer of Property Act by virtue of Section 52. So the first thing is that the Transfer of Property Act is not confined only to a immune property. It also takes care of the movable property as well. There is no difficulty. But Section 52 was restricted to immune property. And the list pendants in a very, I would say, truncated manner was being projected. That as if this concept, the doctrine has its applicability in every sphere of the disputes, provided there is already a pending litigations on the subject matter. That is what was perceived in those judgments also. Then when there is already a pending litigations, irrespective of the subject matter of dispute, then any action will be hit by a doctrine of list pendants. So it is too general and a broad proposition which was brought. My view I already expressed was that it must be in relation to a immutable property.
In fact, Delhi and Calcutta hold the same view as your lordship is.
No, Delhi High Court also says the principle of list. I'll show those orders. Of course, judgments have not come.
All, suppose a writ petition deals with, say, a consultation or an OLR case, which deals with property, then this concept will apply. But if it is tender,
suppose a proceeding is pending, so far as the release of the pension, and then something is being done and the list pendants will come. Now the larger question would be that what should be the meaning assigned to a property?
In fact, Calcutta High Court on
But if when list pendants is said immovable, then we have to go to the definition given in the General Clauses Act.
General Clauses Act.
In fact,
Something
Calcutta High
that
Court
has to or fastened with or embedded to the earth.
Yes.
Even there are judgments of the English courts which says that if the machines are totally embedded to the earth or fastened to the earth, completely attached to it, they are regarded as the immovable. Yes.
Here, my lord, this is just a works contract.
That's why I'm saying it's a contract. I asked him whether it can be extended in a contractual field. The contract relating to a work, whether it can come under the purview of Section 52, it will not. But he says the principles akin to the list pendants that would apply.
And my lords, insofar as the site is concerned, we also have a right to go on to the site. My lords, there is a concluded contract. This honorable court has also held that in case of a concluded contract, the principle of list pendants will apply. My lords,
I have doubts.
Delhi High Court
Let me ponder about the things, but if I still this time I have not persuaded myself. And naturally, I must say that if I have a dissenting view, then I will refer the matter to a larger field. Don't worry. I am not going to decide.
I'll just briefly recapitulate the facts. How this has come here. My lords, what had happened? My lords, what had happened? My lords, we were back. My lords, we had outsourced our bank guarantee to a third party. My lords. Now, this third party, my lords, plays fraud on us. Sale says it's we have created the fraud, but actually the third party has created fraud on us. We have deposited more than 3 crores to the third party to get this bank guarantee, my lords, and they have created a false account, a false, my lords, web account, and my lords, someone was communicating with us that yes, the bank guarantee is in possession. Later on, we discovered that it is fraudulent. Immediately, it is incorrect, and immediately we inform SAIL that this is what has happened. We may be allowed to replace the bank guarantee. Now there was a banning order. After, my lords, we had given a show cause, nothing was considered. The banning order took place. My lords, that is challenged before the Honorable Single Judge. There is a termination order, which is also the subject matter of challenge before the Honorable Single Judge. There is also another matter, my lords, where the directors have also been blacklisted, my lords. That is also under challenge before the Honorable Single Judge. Now the tender, my lords, I cannot challenge. It is a division bench matter, so I cannot challenge this before the Honorable Single Judge. So this is how the matter has come before your lordship. And I am only saying, my lords, generally, my lords, if the tender, if
What
I
has happened? Have you retrieved your money?
Which money, my lord?
Have you retrieved your money from?
That 3 crores which we have paid, my lords, it is a subject matter of a criminal investigation.
Yes.
We have already lodged an FIR.
Correct.
And
What is the
FIR
outcome?
has been registered. They are after those people, they have all absconded. It is there, my lords. Everything is there on record, my lords. We are the victims of fraud.
You must have transferred on in any bank account of any.
Yes, my lords.
So
3 crores has been.
What about that bank account?
My lords, I can produce those bank accounts before your
I
lordship
was
to show.
I'm just
that-
inquiring about being an inquisitive about a fraud, how it is paid, just to know about.
My lord,
It has got nothing to do on this matter.
no, I understand, my lords. I'll show your lordship the accounts to which we have transferred the money also.
And then what happened to the money from that account?
My lords, they said this money they took it and they said that we are going to give you. My
What
lords,
happened to that money?
money
in
they
the
have
account?
all taken it away, my lords. They have taken the money and they have flown, my lords. The police is after them. Nobody. We do not know who they are now.
The account becomes zero.
We
Their
do not
account.
know, my lords. My lords, as of now, my lords, we got acquainted with them through another associate, business associate. And my lords, this is a normal commercial practice where bank accounts, if they fall short, this is a very big work, my lords. We are executing various works and we have 60 years of experience, my lords. We have never been blacklisted anywhere, my lords.
Understand that.
No, my lords, just our credibility, my lords. I'm just trying to express our credibility before your lordship. And because we fell short of this amount, we wanted a bank guarantee and we paid them. And we became the victims of fraud.
Intertwined with these two matters. So, this is the
was carried to the Supreme Court. And SLP was dismissed in limine. It appears that it was dismissed only. Just for your lordship.
It does not determine to merger.
Yes, it does.
It will not
But
tantamount.
that's just.
I'm also
I
aware,
wanted
my
to-
lords, SLP was dismissed. But that will not tantamount to merger.
What else doing that?
There are two other judgments which refer to this judgment and exception. Again, two division bench judgments.
Is it like from your lordships, if they bring this as a concept to tender matters, then the implications would be.
Has a far reaching effect.
The entire work, everything would be in.
Lot of.
In my short note, I have also added
No,
that.
I understood. That's why I put a questions to him in your absence. On the very first day of.
Because I was in
when he
DC,
moved,
I
I
had
put a
matter-
questions to him, considering all these aspects. That an unscrupulous litigant, how he can misuse this particular doctrine. It may be a genuine case for this, but proposition of law which would be laid down, that would invite a anomalous situation in the legal parlance.
In fact, Calcutta High Court, Honorable Justice Sinha has dealt with this. And he has said that these kind of, this is, the word uses, it's misplaced. He has taken note of everything, Tata Cellular and all those judgments. And that was a 1997 Calcutta Medal. That judgment also had gone.
Justice Leslie Sinha.
My lords. Lordship wants, I think, people is.
This is for the living citizens and division bench, chapter 3. Individuals and restriction of single.
No. This is your name on this that I get. Like very much that I know. Even taking from the that is also an inherent pass. First, taking, I can go, I can withdraw any case from any judge. No. But I have to execute for a single bench judge.
Para 16. Five submissions have been known.
Choice.
It is not decided. Paragraph 16 is different.
Paragraph 16, my lord, may kindly see.
No, it's simply said, it's taught about is sold in auctions.
My lord, may kindly see paragraph 5. The submission. Mr. Biswas, learned counsel appearing on behalf of the petitioner, submitted with the reason assigned by the respondents for rejecting the tender of the petitioner are not sustainable, and thus the respondent must be held to have acted unreasonably and unfairly in awarding the contract in favor of the private respondent. The learned counsel in support so and so, this lordship may speak. It was further submitted. That is important. It was
The
further
work done would be held by doctrinal respondents.
Yes.
And then he relied upon this 1992 Karnataka.
My lords. And that has,
Dodappa Apaya Patil judge.
yes. That has been answered in paragraph 16. After taking note of Tata Cellular, subsequent is so and so, reliance on Godappa so and so, Bhimappa is
Paragraph?
equal, paragraph 16. 1-6. Reliance on Godappa
Is equally misplaced.
In that case, it merely has been held that the doctrine of respondents applies to a proceeding.
No doubt about it, provided that proceeding relates to a
Property.
removed property.
And
But it has not been said in a very lucid manner.
Manner is absolutely. But it says that it's not a case of alienation of property.
I understand, sir. That's why I'm saying not in a lucid manner.
Look, there is another judgment by this honorable court. Again, Honorable Chief Justice Sujit Burman Roy and Honorable Justice A.S. Naidu, where they say, my lords, there, my lords, this in a review petition, they say, paragraph 2 is important. It appears that the review petitioner was not, Lordship gets paragraph 2, to the writ application. It is alleged that the petitioner intentionally did not impede the review petitioner as an opposite party in the writ petition.
Last line. Is aided by the doctrine of dispendence.
Yes, Lords. But then fact remains during pendency of the writ application, the opposite party department proceeded to finalize the tender and gave opportunity to other firms to submit the price bids
No,
and
Mr.
also open the
Colombo,
same.
I have the strongest of doubts. It's very difficult to extend the horizon of dispendence.
Delhi High Court also, my lords, extends this to writ applications. In fact,
No, writ petitions, no doubt about it. There is no difficulty. Writ petitions, it talks about the proceedings. There is no problem in this regard. Suit or a proceeding. But I have
Velocity systems versus, of course, these judge, my lords, here your lordships will see.
Loosely using that expression as pending proceeding.
This is what I find everybody, they are the impression when there is a related matter pending, any action which would impinge, that would be hid by doctrinal dispendence.
That's problematic.
In the meantime,
That is why I'm saying that to generalizing this proposition, very difficult.
my lords, otherwise, my lords, my rights will be shattered if, suppose I win before the honorable single judge, my lords. Then,
So there are two ways in these kind of situations in a work contract. Whether the contract has been unreasonably denied to you, or there was any breach or any kind of a things, then in that event, one may definitely have the right to claim a damages.
Yes.
He can claim a damages that he has suffered. When it relates to animal property, then a certain right is created. And the moment a right is affected, then in that event, it says that any action which has been taken on the teeth of the pending litigations or proceedings, then the doctrine of dispendence will definitely apply.
Yes, my lords, division.
And that's why there is a equitable principles which is also applied in the civil cases.
Yes.
That if the property is dealt with and the purchasers have invested the money and purchase, then an equitable defense will also come in his favor, that I am a bona fide purchaser for value without notice. This equitable defense is available to an intending purchaser, where the doctrine of respondents is applied. And therefore, this respondents doctrine is too weak a doctrine in relation to a dealing of the immole property. Now here, what is happening? Now it is being used as a big sword. Any action, any steps taken will be hid by respondents or guided by the respondents or subject to respondents. I do not think that it should go in this way.
Well, your lordships may say that this tender will be subject to the result of these two writ applications. That also, well, that doesn't amount to opening havoc, my lords.
I do not know. I used to react to it there in other court, where the bar was very, I would say, receptive and taking in a very good spirit. I do not want to make it.
We always take a
No,
lordship
no.
in good spirit, my lord. That is not an issue. I'm just saying, my lords, because otherwise your lordships may consider I am the victim of fraud. I am being, my lords.
Only one word I can use, sentence.
My lord.
What cannot be done directly cannot be achieved indirectly.
My lords, ultimately this is a policy. Three division
When you
benches.
talk about subject means what?
My lord,
Is the list pendants.
my lords, three division bench judgments of this honorable court have.
Let me ponder upon the thing. Till
Your
it,
lordship,
I have not persuaded. I may be persuaded after reading it and making a full research.
My lords, we'll also try to aid your lordship, my lords. Lordship,
My genetic problem is that I start from the scratch. That from where this list pendants theory or the doctrine evolves, and then goes on how it is developed. Just to understand that whether we can expand its applicability.
In fact, one of my further arguments will be that once it is a policy as held by the apex court as well as our own high court, it's a policy of equity, good conscience and fair play. Then, my lords, there is no prohibition for expanding it to contractual matters, my lords, tender matters. There is no embargo per se in the TP Act itself. This is a principle which has emerged from common law and which embodies, my lords, equity, fair play.
What you say is
yes,
more apt, and it is used there in West Bengal. Unique thing is that the Easement Act is not extended to the state of West Bengal. Does not apply. Nobody knows what I'm telling. Everybody thought Easement Act, they apply sections and all everything, but it has not been extended to the state of West Bengal. I do not know whether it has been extended here or not.
No, it is.
I do not know. The Punjab has its own Easement Act, different. So it says that it may not apply, but justice, equity, good conscience, that would guide the finance. So the principles akin to an easementary right, that is applicable there. So we apply the easementary right by prescriptions, we apply the easementary right or easementary right by necessity. So all these are inbuilt. But not the easementary right when you invested the money and develop and then claim an equity or the easementary right over the property. No, you can't. In West Bengal, I do not know. When you talk about the good conscience, that's why. Justice, equity, and good conscience.
Yes. That is what I'm saying, Malos. Once these are principles which emerge from common law rights. In fact, Malos, it's interesting that in a matter in the Delhi High Court, another matter, Malos, same Bhilai Engineering versus Steel Authority. Again, the principle of list pendants was made applicable.
We'll go by 2005 judgment of the Supreme Court. When the Supreme Court judgment is staring at the field, Article 140.
Yes. Supreme Court, then I wouldn't have been. Well, let's see. Well, you'll also see this order of the Delhi High Court.
Apart from 5 principles, 6 principles was also admitted.
This order, I will not say it's a judgment. This was an order. It is made clear that the respondents, this is between the same parties. Bhilai Engineering, sale. We are still litigating, Malats. Some other matter. It is made clear that the respondents are at liberty to go ahead with the tender process. However, principles of respondents will apply to the entire proceedings.
Whether your the rules permits consolidation of all those proceedings pending before the single bench and a revision bench.
That minutes in view of the Supreme Court judgment, the Honorable Chief Justice
No, no, the difficulty is the Chief Justice is a master of the roster.
So your
Master
lordships
of the
can call
roster
for
has a power to take any file from the judge. But the difficulty is that can be exercised by the Chief Justice, but it has to be assigned to another single bench. Can he usurp the power and take it to a division bench?
Yes.
Because
Yeah.
one reason is that the litigant will lose one forum.
Yes. That is
that
the
power with the honorable chief
writ
justice.
appellate for a
Where from the rules can you show me that power?
Lordship is right, because the writ appellate forum one. But
There is one
But-
judgment, that's why I'm.
yes, my lords, but your
there's one
lordship will
judgment.
take sometime.
Talks about that losing of one forum.
Yes, my lords. And your lordships, in some matters, this a division bench when interconnected matters are all pending.
No, if all matters are related to a division bench, it can be consolidated.
Certainly,
The different-
then there is no problem.
But the difficulty is some from the single bench, some from the division bench, whether. Because there the rules permits. The power is given to the Chief Justice that it can consolidate the matters even of a single bench to a division. Yes?
To do complete justice.
No. That is the expression, the Latin is ex debito gestace. What? But I do not find whether that power is there or not.
Now we'll
Because
check up
once
the
it
rules.
is guided by the rules. Then
We'll check up
the
the rules.
rule which is framed by the full court.
Yes, but we'll check up the rules. High Court.
Whether it can, so I want to consolidate all the matters
Well, I'll check.
and decide one. No, sale has provided, sale, by law. These rules is the law. Contrary these rules.
So this I was referring to rule 10, chapter 3.
Rule 10.
Chapter is. Ten cannot.
Well, we'll check up the.
Yes.
There's one judgment, colors 96-4 SCC 433, Vikas says, which defines property. Now, the two distinctions, tangible and intangible.
Tangible and intangible,
So they recognize that IPR rights.
Correct.
There they say that that is also property.
True.
If your lordship holds now only immovable property, then no IPR is
Because the difficulty is that section 52 talks about immovable property. Uses the word immovable property. That is what is there. So lispendence, whether it is a common law principles or it is recognized under section 52. If we go by a 52 principles, then it is a immovable property. Because the section itself talks about immovable. It does not talk about the tangible or ostensible or intangible properties. It does not talk about that.
No.
By judgment side law, my lords, they
But the doctrine, whether this doctrine can, apart from the legal recognition or bringing into a legal document, can apply as a common law principles.
Has to be seen is as far as general clause act is concerned.
The general clauses act defines immovable property, and
The
immovable
difficulty
property is
here
a very difficult one.
Many states have their independent general clause.
No, I understand, but they have not defined differently.
No,
No.
the same thing.
Only
Embedded.
thing, same thing they have done it.
But my lords, it
and
relates
scope
to intangible properties. I mean, tangible properties also.
The scope also of the work has to be seen because if it is in a boot mode, build, own, operate, transfer, then the ownership stays with the contract.
No, that you say, but here is, suppose a work contract is there. It is really a contract to do a work.
Whether it is a turnkey project or
Is
not.
a turnkey project is a different one. So a turnkey project where from the very scratch, finding out our land and
Yes,
then
yes.
installing the machines and making it operational and handing over to the contractor. That is a different concept at all.
No, here the site is given to us by the
I
contractee.
understand to
And
make a development. Now,
we have to make build a coke plant on the site, access to the site.
only thing is, there are two concepts, then also I'm thinking. Authority coupled with the grant. Yes. Whether it will come. And whether that grant creates any right into the immune property.
Yes.
By virtue of an authority. That one has to understand.
And if they are taking a coke plant, that is the immovable problem.
The site
Like I am conscious, like a development agreement.
Yes.
The developers does not really have a right into the immutable property. It remains with the owner.
Owner.
Yes.
It is by virtue of an agreement, the developer is given a right to develop on the property of the owner.
Yes.
So he invests, constructs, and then moves. But this is kind of hybrid kind of an agreement where maybe he's acting as an agent of the owner, but having a right.
We have a definite right to the property, Malos, because we are to build on the site and they have given us access to the site, which of course is an immovable property.
In all the
Yes,
perspectives,
sir. Your lordships will. We have
I
cited.
can give you a multiple example which is
Yes,
hovering in my mind.
Exactly. Malos, we have also given the relevant clauses. Your lordships will keep it to another day, Malos, if we can assist you lordships on this point. Any further, Malos, we'll check up.
Because the difficulty is
We'll also file, they have filed a counter yesterday, so we'll also file a rejoinder.
Yes, right. So we can by 1 week. Matter to be listed for 1 week. Yeah.
2 weeks within 2 weeks.
Okay. Yes.
Two more minutes.
Obliging.
49.
When a compliance certificate and copy I am submitting today, I will sign just by ready and file the code. They will come next week.
Tomorrow, next week.
Yes. Item 50.
I is reading you can not see.
Lordships, item 50, item 50, I'm being led by Mr. Anirban Ray. Lordship, he's on his legs currently, like your lordship he's requested your lordship to kindly fix a date so he can physically come down and argue this matter, your lordship.
What is the matter about?
Because that arbitral award has been set aside.
Section 34 allows.
No, writ petition 30%.
Oh, 30.
Your lordship.
I have already shared
Yes,
one of the.
yes, sometime.
I have already.
Yes,
And the SLP has been filed.
No, your lordship, I'll just. Your lordship, what has happened in this matter?
No. I think while sitting.
Your lordship had asked me one question. A review petition has been filed on a different ground.
All the judgments, including Bhavesh construction.
A review.
Your
lordship had asked two questions. Your
After SPP, Patel engineering and
Yes.
everything, the
Yes,
judgment
sir.
I have seen a subsequent judgment. And the scope is very limited.
Yes, sir. Your lordship, my review petition has been filed and it has been heard and it has been kept for pronouncement of judgment.
What is this?
This
Another matter?
Same matter, your lordship. I'm in that writ petition 32426, I have filed a review petition on a different ground. My ground is
I do not know. This is the review petition.
Yes, I filed a review petition before the writ court.
Review of this order.
No, review of the writ petition.
Impugned.
Impugned.
This order means which was challenged.
Yes, sir.
Appeal.
Yes, sir. Yes.
After this order is affirmed
Yes, sir.
or set aside.
I have filed a review on the ground, which is very different. I'll
Oh, I am trying to understand. I am really surprised by this, that an appellate court has set aside the order passed by the single bench, and then the review application of the single bench order out is maintainable.
Right.
I don't know. You just did sunflat. Review is filed. You have filed, you just revision order.
Oh, this is another one. Sorry, my bad.
So, Your Lordship, I have filed a review that the parties cannot be delegated
That
back.
does not mean that the appellate court will not.
I understand, Your Lordship, but judicial propriety says because I have
That the
I
review
cannot raise
will
those.
be maintainable, the appellate court will decide.
Your Lordship, because the grounds are under Order 47 Rule 2, it says CPC, if the grounds are different, because my ground over there was, as Your Lordship held, that it cannot be relegated back.
The review is only applicable on the parameters or the grounds enumerated under Rule 1 of 47.
Yes, Your Lord.
Order 47.
Yes, Your Lord.
Now, it says that in the event an appeal is also filed,
Yes, sir.
and the appellate court has decided the matter on merit,
Right.
then it will impact the review.
Yeah, but Order 47 Rule 2 says if the grounds are different. Here, my question is.
Please look at it, what the
Yes.
grounds are different, and the
Yeah.
appellate court. Let us see.
I have a judgment also, Your Lordship, had asked me that if you have any judge.
Yes.
Your Lordship, may I read 47(2)?
Please. Order 47, Rule 2 or sub Rule 2?
Rule 2, yes.
Rule 2 is omitted.
A party who is not appealing.
No, the Rule 2 has been omitted.
Your Lordship, here in my.
You are talking about Rule 1, sub Rule 2.
Sir. Your Lordship. Yeah.
Rule 2.
No, Your Lordship. You are right. Sub Rule 1, sub Rule 2.
Yeah.
A party who is not appealing from a decree or order may apply for a judgment, a review of a judgment, notwithstanding the pendency of an appeal by some other party, except where the ground of such appeal is common to the application and the appellant, or where, being respondent, he can present to the appellate court the case on which he applied for the review. In my case, Your Lord.
What you read from there? It says that mere filing an appeal by somebody else does not prevent the other party to file a review.
Yes, Your Lord.
Simply, it
Yes, sir.
recognizes the right to file a review.
That's
It
fine.
does not say that the appellate court will stop the hearing
I
of the
agree.
appeal as the review is filed.
I agree.
Or if the entire judgment is set aside or affirmed in toto, then the review would still be maintainable and be decided by the.
I agree with Your Lordship. Only my only problem is the grounds that I have taken there. Because since I have filed my review, my grounds are different from the appellant's ground. The grounds what I have filed in the review is.
Now I'm giving you. Now
Right.
you have opened a very big Pandora box for all time to come. I'm giving.
Right.
An appellate court is approached by, say, out of 5 defendants, 1 defendant.
Right.
Challenging the order that this order is bad.
Right.
Appellate court decides and held that I do not find any illegality in the order of the trial.
Right.
So now another defendant files a review application saying that this is the error apparent on the face of the record, or I have discovered a new and important document,
right,
which despite due diligence was not within my knowledge.
Right.
And therefore, I should be permitted to file the review and the order be reviewed. what the review court will do. Suppose he found the new and important documents are very important and due diligence concept you have satisfied. What the court will do, it will review its order. Can he review its order in a partial manner? Can there be a partial review of the order? I have not got that concept. It will be the order in its entirety will be reviewed.
Right, Your Lordship.
And the order is affirmed by the appellate court. What would happen to the order of the appellate court?
Your Lordship, in a few matters when
So there cannot be two inconsistent order to operate in a field simultaneously. So what will happen to the appellate court order? Tell me.
Your Lordship, if the appellate court, for example, a party has
Let us see. Take a very, very strong examples.
Right.
A appeal can be filed on a multiple grounds.
Right.
Challenging the order that is the ultimate order is wrong by the trial court. Appellate court decided the plea only on the ground of res judicata. Let us see. Understand?
Yes.
And says that appeal is dismissed, the judgment of the trial court is affirmed. Can the review lie on the ground of, say, waiver? Let us be in a different, not res judicata, waiver. Can it lie? It's a different ground, not on that ground in which the appeal is decided. Let us go to that extreme.
Right.
Already a merger.
I am coming. Can it lie?
It will be a merger if the court has decided on the or decided all the contentions.
Once the
But if it
appeal
has
is filed,
Right.
appeal cannot be filed against a part decree, except only exception is when a release is in part is substantially granted to the plaintiff, and the plaintiff for the rest of the relief has approached the court.
Now
Otherwise, if the entire relief is granted by the to the plaintiff, the defendant cannot file an appeal challenging a partial portion. And
Your Lordship, in my case, what has happened, I'll give you my fact. The reason why I had filed a review. Your Lordship,
on your concern, you can file a review.
Your Lordship,
Does it create?
No, it doesn't. It doesn't deter. But
No,
at
let us
least
decide the appeal on this ground.
judicial proprietary principle should be taken if, for Your Lordship, if my order in review stands, like whatever I have filed for a review, it stands, then a new order is created.
New order?
Means, obviously, Your Lordship,
No, sir, even a review is rejected, it does not tantamount to.
No, Your Lordship, my review is allowed. Then there is a order, there is a change in the order. My application over there under writ is that I should not be relegated, as Your Lordship on 8/7/25 had passed an order stating that the parties cannot be relegated back to arbitration. That's the question that I have put before that court under review.
No,
stating when both parties.
The appeal has to be where is Mr. Anirban Ray?
Lordship, he's on his legs right now, Your Lordship.
I will file a counter also, Your Lordship, in that case, because all these questions that I have raised before the review court needs to be brought before this court. Here what has happened, Your Lordship, parties have already waived their arbitration clause by filing their respective civil suits. And on the basis, because the lease agreement was unstamped, and it was objected also, Your Lordship. Section 36 is not applicable.
Sir, this unstamped theory is different.
No.
It has originated because of the SMT judgment of the apex court.
Right, Your Lordship.
Now, there are two concepts. One is the document which is unstamped or insufficiently stamped, that attracts section 33 and the 35 of the Indian Stamp Act.
Absolutely.
And the document which is unregistered, that section 49 of the Registration Act will come into play.
Yes, sir.
There is a vast distinction between these two concepts.
Yes, sir.
an unregistered, unstamped or insufficient stamped document is admissible in evidence provided it is impounded by virtue of section 33, 35. Secondly, even if you put the stamp duty correctly, if the document is compulsorily registrable under section 17 of the Registration Act, having not registered under section 49 cannot be received in evidence. Exception is only two. One is no. One is if it is in relation to a specific performance of an agreement for sale, then also unregistered document you can apply, or any for collateral purposes.
Exactly.
Till date, what is the meaning of collateral purposes is unknown to anybody and everybody.
Here in this case,
I'm telling you,
yes,
it
sir.
says collateral, but it is unknown that what
is
does it
exactly
mean.
the term?
Attempt is being made to define, but it is still in a very gray area.
Right.
So now question is, SMT says that once the document is unstamped, unregistered, SMST judgment of the Supreme Court. That is the first judgment.
Yes, sir.
Which comes out.
2000.
It says that it brings two distinguishing features. One in relation to 33 and 35. If you look at the language, both languages are same, except one noticeable distinction. In 35, the word acted upon is used.
Yes.
In 33, it is not used.
Exactly.
Not used.
That is a one.
Then it says that so far as the acted upon the document is concerned, then it cannot be acted upon.
That's exactly my case.
It cannot be acted upon.
Yes.
Means the court will stay its hand.
Yes.
And will not look into that document.
Yes, sir.
Now the question, then second question that arose was that does it mean, what would be the stage when section 35 would come into play?
Yes.
Does it come into play at the time of an interlocutory stage or at the time of tendering the document by the witness standing in the witness box to be received in evidence? Two questions. Because the word used, the authority who has the authority to receive a document in evidence shall not receive the document in evidence unless impounded. So this is what is the exact principle. Interlocutory applications are decided on affidavit where the documents are not tendered to be received in evidence. Does it apply at that stage as well?
Right. So in my case, what has happened?
No. The difficulty is this.
Okay.
Now that it was diluted in a subsequent decision.
Yeah.
Garware, that came to some extent. Then there was 5 or 3 NN Globals that came into 3 or 3. One by a 3 judge, one by a 5 judge, and another subsequently by a 7 judge. The concept is that one judgment it says that moment the document is not registered, it is a void document. Says it can't be a void. Ultimately, it is held that no, there is no difficulty. Impounding has to be done. And unless the document is impounded, the SMST principle has been borrowed. In the meantime, Vidya Drolia judgment that really came and intervenes. There are many things that happen, sir.
Yes, sir. I agree with you.
And everybody overlooked section 36 of the Stamp Act.
Yes. In my case, 36 is not applicable.
I'm saying 36 is ignored by everybody. What it says?
It says if it has been admitted.
Already admitted, then it cannot be questioned.
Yes.
That it is understamped or unstamped.
Right.
The court has to.
But if there is an objection, prior to admission, in my case, there was an objection.
No objection. Then what?
Then it was ordered to be impounded by this Honorable High Court. The Honorable High Court ordered that to be impounded. So that has not been cured.
Now the question is that these are all the concepts which originates in the civil law. But now, what is the jurisdiction of a review court? As a writ court.
Writ court, madam.
Yeah.
What is the jurisdiction of a writ?
Writ.
How far it can go? I have decided
Lordship,
beyond.
SPV judgment also. SPV
Patel
judgment also
Engineering, SBP,
helps-
Patel Engineering,
helps me.
2005.
In SPV judgment,
It says you'll have to just wait.
wait.
And when you challenge the award under section 34, you take that plea there.
Your Lordship, one question is, can the arbitrator dilute or avoid a judicial order? So SPV judgment talks about that a
Now that's
judicial
why
order.
I'm saying nobody has taken note of section 36.
Here in my case, it is totally
And
not
it
applicable.
was a case which I decided. It was a case which I decided that everything was already done. Rather, we decided. It was exhibited and all, everything taken into evidence. After the 7-base judgment of the NN Global came, application was there that you cannot receive it, impound it.
Yes.
The arbitrator said, sorry, I'm not going it. We have already accepted it as an evidence. We can't go into it. And thereafter, the matter rolled into the writ court. The writ court started interfering.
So NN Global 7 is only about whether an appointment can be made or not.
Sir, these SMST to all, everything, the cases
The curing part is there,
originate from an application under section 11 of the arbitration constitution.
Your Lordship, there are several
Originate.
judgments of Supreme Court without curing. Even NN Global 7 says that without curing you cannot proceed. Curing has to be done.
I am again saying, sir, not proceed. The question is
Adjudicate.
whether no.
226.
The adjudication can be done, deholds that document.
Yes,
It
sir.
not be done.
Yes, sir.
Proceed, do not say. That
Okay.
means it put a complete fetter into the arbitral
But in
tribunal
particular
to
to
proceed.
that document, I agree.
That's true. That's the only question is
Yes.
to be taken into consideration.
Right, Your Lord.
Now, again, I am saying section 36 has been overlooked.
Your Lordship's own judgment I have, where Your Lordship has in Calcutta High Court
With Justice Hiranmoy Bhattacharya.
Yes, Your Lordship. Yes, sir.
And I have taken a view of section 36
Yes,
to
sir.
the great extent.
Yes, Your Lordship.
I says you can't.
Your Lordship.
Once it is exhibited, no, you can't.
Prior to that, Your Lordship has held that if there is an objection, you cannot exit.
You have to impound it.
Yes. That is my
before receiving the document.
Yes, sir. That is my case.
And this was a different case.
That is my exactly
The
that
sun flag is the case where it was already received in evidence.
No, my case, prior to receiving, there was a court order to impound it. And it has been impounded by the arbitrator also.
Arbitrator can't impound.
Arbitrator has to impound, Your Lordship. Pursuant to the direction of the High Court. Under WPC 7893 of 2007, the High Court directed because the arbitrator refused to impound.
Anyhow, we'll consider your case.
Yes.
The question is whether 226 will.
No, it's a collector who has to ascertain the stamp duty. And then after that, he has to pay 10 times the.
Under the stamp and fees.
Yes, exactly.
10 times the duty. And then
It was sent to the collector, but it has not been cured. They had put the entire onus on me. There are judgments where courts or a tribunal cannot put the onus on a party that you will pay. As long as the party says that I'm ready to pay. And as per the agreement, it is the lessee who was supposed to pay, not me. And
Well,
then,
that
because
will
of
not be.
this,
will decide that whose onus is to pay or liability.
it is
The person who will bring it on evidence
The person who tendered the document
tenders the document.
ability to cure it.
You're not.
You cannot go and decide some ancillary point that whether the lesser is liable to pay or lessee is liable to pay.
I have not tendered it as
I do not know in 226 how
he has tendered because he has taken it as on a collateral basis. The judgment.
Collateral is in respect of.
I can rely upon without stamping.
You know your Lord.
Not in respect of a stamp duty.
That's the reason the award has been passed on an unstamped on the basis of being it collateral, which cannot
Award
be
has been.
I am on the
not
point.
remained.
Your Lordship, And
Then it is already received in evidence.
Your Lordship, prior to that, impounding order has been passed, which has not been cured.
I do not
And
know.
there are judgments, the yellow judgment, Your Lordship, which says that even there is another judgment recent, which says that even if the court there was an objection and the court, despite the objection, has passed an order, such an order is a nullity. There is a Supreme Court judgment on.
What is the nature?
And why will he not go by section 34?
I do not know whether the order of impounding was passed or not.
Yes, sir.
I do not know. That all depends upon the factual matrix.
Right.
But on the question is the writ jurisdiction. Whether
Which jurisdiction?
I am more concerned. We are not, since you raise a particular issue, so I have responded to it.
Right.
But we are more concerned with the writ court's jurisdiction to interfere with the award or
Private award,
the order passed by the arbitral tribunal.
There are several judgments where it says
I have considered all the judgments.
Yes, sir.
And once the SPP 5-judge based decision is there,
Right,
it
sir.
says that no, you should wait till 34 occasion arises. Then I do not feel. There are subsequent judgments which I have taken note of where it says so.
I'll provide.
But no, these judgments I've taken note of.
Right.
Have you read this judgment fullest?
Which one you want?
This one, Sunflag.
I haven't read.
You have not. I have considered all subsequent judgment where the Supreme Court have taken into consideration
These judgments.
took into account that yes, rate court, but limited to an extent that how far it should go.
Right.
It cannot go in this way.
And here
I have considered, which we will be relying on this Fures de Lawson's judgment.
Yes, Your Honor. Continuity about
Deep Industries Limited. You will find there's a ONGC's judgment.
Bhavin Construction also.
2020. Yeah, I have taken note of it.
And in those Bhavin and Deep, Your Lordship, and
absolutely. Then Punjab State Power Corporation Limited. That's a AMTA core. AMTA core. I have considered. Bhavin Constructions. I have taken into considerations. No difficulty. All the latest judgment.
Here more.
Then I have taken MT Creations and others.
Right.
Judgment of 2023. And I have also taken consideration Mani Tirumala Projects Limited. That judgment is also there. Which really talks about that how far writ court should go.
This is one aspect, Your Lordship. The second aspect is, since the agreement was unstamped, what the parties did, they went and filed civil suit. So once you file,
this may be a good ground somewhere else, but with writ court
and a section,
how writ court will enter into this aspect.
My question
you may have one of the best case on a civil side, but whether the writ court.
My question is whether after failing under section 8, can a party, instead of filing 37, can I say that he didn't file 37? I should come under 34.
You come under section 37 appeal. I will hear you.
No,
you come under the other
37. He has to, not me.
You come under other revisional jurisdiction. I will certainly think about it.
Yes,
No, why should I come in a 30 minutes?
You come under Article 226. Actually, the difference is our mindset is groomed in a manner. In Calcutta High Court, the application under Article 227 is always regarded as a revisional application. And it is considered as the revisional jurisdiction of the High Court. And 227 is a writ jurisdiction.
Mine was
blend both 226 and 227.
Yes.
Create some kind of a.
I will satisfy Your Lordship that the award is a fraud award. And it has been passed.
Fraud award, but it also is a provision under section 34.
It has been passed by
section 34 talks about a fraud award.
Yes.
And that is why stamp there is no security required for a fraud award.
Even the government says that if there is a debt,
read my judgment, our judgment, not my brothers.
Will read that.
And tell us that we are wrong. And still we are open. I think both of us we are very open. If we find that we have committed wrong, we are bold enough to say that we have.
Mine would be on a different.
May I just request one thing, my lord? My lord, may I just request one thing?
Yes, next week.
My lord,
Your lordship, at least give me 3
Next week.
21st, 21st, my lord, if possible.
Your lordship, there are a lot of,
Nothing.
There are a lot of.
We are on a only solitary point whether the writ jurisdiction can be invoked in such way. That's all.
Say lordship.
That's a pure question of law.
Just give me 2 weeks time.
That's the thing. 2 weeks, give a day.
Mine is tomorrow.
Yes.
2 weeks, 21st, ko to bolo. 21st, 21st,
25.
85.
25, sir.
25, ठीक है, चलो 25 तक
25. Again.
25, sir.
25, 25.